All right, let's do this. Long time coming, but let's have the debate of the century. This probably beats Trump Biden. I think it might get more views than Trump Biden debate. Anyway, we're going to talk about the Clayton Echard, Laura Owens case right now. We'll bring in hot bench's own Rachel Juarez. Rachel, thank you for coming on.
Thank you.
And then, I mean, without any further introduction, let's bring him on.
Point.
It's baby Dingus. It's Dingus.
Yeah.
You even put your name in as Dingus.
Steve, you don't know me that well, but as we go along here, I'd like to think at some point you can figure out I got a little bit of a sense of humor. It's not very good. I'm not Dave Neal. But I'm light. All
right. With 5 seconds in, you're fucking taking shots at Dave.
I have to talk about Dave. I'm not taking shots. I brought my Trump mug for those who celebrate, which is not me. This is sarcasm. Yeah. But thank you for having me on. I appreciate it. This is going to be a friendly debate. I promise you that.
Yeah.
I have no ill will towards anyone sitting on this screen.
It's just everyone else online you have ill will with.
I only sound that way. I promise you that. Again, you don't.
You can only go off what you present to us, which is
fair enough.
I'm a dick, and I'm going to go off, on you trolls.
That's more reason to have done this, and I appreciate you giving me the opportunity to talk to you guys. And this is I can't believe looking at the calendar that it's April the 3rd, right? 2025. Yeah. I remember a year ago getting hired for this. It was literally March 25th, I think it was, something like that. Yeah, and I was the guy who kept saying, I'm going to try to do things right, and I'm going to try. I don't know all the facts, and I'm still partially. Yeah, well, I'm still partially, burdened by that. And you and I have talked a bit now, and I've emphasized to you that I'm super happy to talk about, everything from my involvement forward to the extent that I can. I'll comment a little bit about some past things that I wasn't involved in. But I told you, Steve, that, I don't want to fight you about the law because you're not a lawyer. And I don't want to fight you about the facts that I don't know because I wasn't involved in. Doesn't mean I don't care. Doesn't mean I don't care. Doesn't mean I don't think they're important. But I don't want to misstate anything. I mean, people are so hanging on errors, right? I mean, my Twitter was just blowing up over people, and I don't know if this goes back to Mr. Neal. Am I allowed to talk about him? I mean, I'm not going to beat the guy up.
You can, but we'll take it on a case-by-case basis of what you choose to say about him.
Fair enough. But somebody on Twitter was blowing me up because they said, Mata made a finding, or that there was a December 2023 RavGen test, and I don't know why they thought that was significant, that there was this December 12th or something. I literally just was tweeting about it, and they were saying, Dingus doesn't know about all the facts of the case. And I was like, what are you talking about? There was no December test. And sure enough, it's one of those things. You go back to Mata's post-trial findings, it's there. There was no exhibit about it. It wasn't talked about at trial. It was just, we figured out where it came from. It came from Woodnick's pretrial. He just put it in there, but there's no exhibit. There's no document. I've never seen such a test. I don't know if it's a typo, whatever, but you know what I mean? That's my attitude going forward. I really want to be careful, Steve. I actually do care about accuracy, truth. Everybody does make mistakes. We make typos. We misspeak unintentionally. I don't want to do that. That's part of my hesitation to go into areas I'm not familiar with, if that makes sense to you.
And I just wanted to let everybody know, for the record, we're going to have a good 90 minutes to 100 minutes on this. And we're not going to get to everything because a lot of people that are going to be watching this video are obviously the people that have been invested in this case since long before you even took over for Laura. So there's a lot of people that are interested. I know they have a shit ton of questions. We're going to get to as many as we can, but we're not going to, there's no way we can cover everything because you and I both know we can talk for 5 hours about everything that's been involved since you took over in the last 10 months.
How much time would you say, and I'm not trying to ask you to reveal any trade secrets here, but how much time have you and I actually spent talking? Because, we haven't had
4 phone calls that were back in November and December, which were around 30 to 45 minutes each. And then our phone call earlier today, which was another hour. So maybe close to 4 hours total.
And to me,
and then texts.
It feels like, Steve, that we're just scratching the surface. I mean, we really are. And I realize I want to get information to you. So let's get into whatever you want to get into. Yeah. Chatting and talking is nice and everything, but I know you have questions. You hit me up with some of them today. I'm going to do my best to talk about them. And I actually genuinely want to hear Rachel's input. I do. And Rachel, I'll tell you, because I've never spoken to you directly before, that the entirety of my knowledge of you is limited to listening to the one thing that you and Steve did, that I did a live stream after. I listened when I drove down to Tucson to pick up my niece. I listened to you guys and I loved it. I thought it was great. I have massive, massive respect for Yale. Did you go to Yale? Is that where it was?
I did, as an undergrad. Yes.
Yeah. That's shot. My dad went to Dartmouth. I know what that level is like. And so if I ever say anything as we go along here, like if I ask you how many appeals you've worked on, and if the answer is not very many or whatever, please understand that you have my complete and total respect. I'm not questioning your skills.
That's okay.
Fair enough. Okay. So Steve, hit
me
with.
So basically what I wanted to do is just let everybody know right off the bat, we're not going to get to everything that I know some of the people out there want, but we're going to cover a lot. And what I like to do in my interviews is kind of go chronologically. There will probably be some things that will bring us back to something when you give an answer. We might have to go backwards a little bit, but I want to go chronologically, and I want to kind of start at the trial that was in June of last year. And I'm not going to sit here and be like, hey, when Dr. Medchill said this, we disagree. We're not going to do that. But there are two general questions. And when I say I want to know, I'm also, I think, taking the consensus of the Justice for Clayton crew when they want to know certain things. So I'm going to be like the mouthpiece. A lot of this thing will be me just moderating and just getting us from topic to topic. I'm sure there will be some memes where people can make, so I'll probably have some facial reactions, some eye rolls, whatever. But
from this guy,
yeah. And then and if I'm not looking at you guys and I'm on my phone, it's because I'm making notes on my phone because I don't want to type because the sound will get out over the air. So I will be looking at my phone to just take notes and maybe give myself a hey, ask this or whatever on a follow-up or something.
Okay, so we're June 10th, 2024. Lovely warm summer day in Phoenix. Let's go. Let's go back in time because it was a lovely day for me.
So for June 10th, for the trial, there are two things that stick out for me and a lot of people that we want to talk about in generalizations of the trial. The first question is this. You never got a chance and you never got around to cross-examining Clayton, which to a lot of people was just like, why did he waste 45 minutes or whatever it was? It might have been 40 minutes on Laura on stuff that the judge probably already knew. We all already knew. She didn't say anything that we didn't already know. It had been in depositions and stuff. And you never even got around to cross-examining the one guy you would think, you being the guy that you are, probably wanted to grill him like no other. So what is your answer to why you never got around to cross-examining Clayton? And did you want to cross-examine Clayton?
So it's such a good question. I totally adore this question because I would ask the same thing if I were in your shoes or JFC shoes. Why would you not talk to like the main guy, right? Yeah. Obviously, time was not allowed for all the things to happen. But prior to trial, I had, and I think we agreed that 4 people testified, right? It was Clayton, Laura, and the 2 experts, Deans and Medchill. That was it, our cast of 4. I had binders and notebooks ready to go for like 10, including their forensic expert, Gillespie, Maricini. I had a full list of questions because I just naively thought that this 2-hour thing was maybe going to be flexible. But once Judge Mata told us in the morning when we first got there, she said, I'm not giving you a second more time. In fact, it was worse than that. When we walked into her chambers and had our initial sort of meeting, she said, look, there's something called invoking the rule. And invoking the rule, it's called the rule of exclusion. Normally, if you've ever been to a trial, people that are witnesses, expected trial witnesses, are not allowed to sit in the courtroom and watch. If somebody invokes the rule, it's if you're a witness, we kick you out. Okay. And so Mata said, if you want to invoke the rule, which is normally just to prevent witnesses from hearing what someone else said so they can kind of make their stories line up. It's a good rule. But she said, if you want to do that, I'm going to subtract the time it takes for people to walk to the courtroom from wherever they're waiting. And I've never, ever in my life had a judge say something like that. I appreciate Rachel's reaction.
You've never been in front of David Carter, have you?
I have not. I've done jury trials and bench trials, and judges, I think, generally look at flexibility as being the standard because due process is not a joke. We try to have a fair hearing, even if sometimes we have to be flexible. And Mata made it very clear that she was not flexible and was going to be extremely harsh on this time thing. And that's why when we came out of there, I was like, my God, we can't, if we have witnesses walking to the thing for 5 minutes and I've got 50, I'm like, okay, everyone just stay here, which is why everyone was allowed to remain in the courtroom, which that shouldn't have been done that way. To answer your question about Clayton, I had a list of questions for him. I had a list of exhibits for him. And by the way, I don't know if people know this or even care. My entire exposure to Mr. Echard, we had a settlement conference the court ordered us to. I actually told Greg that I would be willing to have him and Clayton and everybody sit down in a room. I mean, that's what you would normally do in that situation. I am a big believer in mediation, arbitration, people working out their disputes. I'm a big fan of that. And you can't resolve things unless you talk, right? So I offered that and Woodnick refused. He wouldn't let Clayton and Laura speak to each other, but I talked to him on a Zoom. It was me and Woodnick and Clayton. So we had a conversation. I don't even remember how long it was, maybe 15 minutes, something like that. And I didn't watch Clayton's season of The Bachelor, so I didn't know anything about him. I didn't know anything about this case before I got involved. I just knew him for 10 minutes on a Zoom. Okay, but getting back to your question, why didn't I ask him any questions? Number one, there wasn't time. And number two, when I thought about it before trial, and I was writing my questions and thinking about what do I need this guy for? What do I need Clayton? Because that's really, whenever I get involved in a trial of any kind, I always start with, literally on day one, I start with jury instructions. I start with jury instructions that is what you read to the jury at the end of the case. And I do that from day one when I'm starting, because the jury instructions usually have a list of elements of what the case, what the claims, what you have to prove to win your claim or to defeat a claim. So you need to know what those elements are. And then you focus your discovery on getting those elements proven or disproven. You follow me? There was no element to our trial that required Clayton's input. There was not. And this is something, Steve, I'm going to ask for you to be flexible and open-minded. Okay. I'm going to give you the same courtesy. And I'm not suggesting that your views on this are wrong. You're just a guy who's interested in a case and the situation and the people involved. Totally fair, totally understandable. I don't look at it that way. I look at this like a doctor looking at a patient on the table in front of him. You don't even see a person, right? You just see the body and like what organ you're working on. And you just think, what do I need to do to get this person off the table and onto the next thing? So I thought about, what do I need Clayton for? Absolutely nothing. What issue could he testify to that would make any difference to the issues that were subject to the hearing on June 10th? Like, I still think the June 10th hearing should never have happened, first of all. If the issue was really just limited to sanctions, do you think that's what it was? I think it kind of was. I think it was broader than that. I think Woodnick was trying to prove that Laura lied about the whole thing. I think that's what he wanted the hearing to be about. And that really is what it was ultimately about. But from my perspective, this was a petition to establish paternity. That is what Laura filed, a petition to establish paternity. And she checked a box that said there should be a parenting plan. All right. She, on December 28th, told the court, I'm not pregnant anymore. There's no child coming out. Not 1 minute of time was ever spent talking about parenting plans. The issue of paternity, I saw it as being moot. So really, we didn't need to fight over that. Fighting over attorney's fees. Should there be fees awarded? Again, I think Clayton's approach was Laura was never pregnant, therefore I get fees for everything, right? I mean, that's what actually ended up happening. I don't know if the question boiled down to, and in a sanctions context, I think, and Rachel, please, disagree with me if you think I'm wrong. The question for sanctions is usually not, is the person right or wrong? The question would not have been, if we were only fighting over sanctions, it would not have been, was Laura pregnant or not? The question would have been, did she have reasons to think that she was, even if she was wrong? If she made a good faith mistake, Rachel, I appreciate you're nodding.
Absolutely.
You think I'm right.
Whether she ended up being right or wrong.
She could end up being wrong. Any lawyer who's been around the block more than a few minutes has been involved in cases where you start out thinking A and you wind up realizing that A is not correct. Okay. That is not, you don't get sanctioned for being wrong. You get sanctioned for being knowingly wrong, or for being wrong and not having a good faith basis for thinking that you were right. So I saw the issue as being so unbelievably narrow, limited to, did Laura have any grounds, any good faith grounds to think that she was pregnant? And yes, I know that the comeback to that, I know exactly what your response to that would be, because I would argue that how would a woman prove that she had a good faith basis to think that she was pregnant? Well, I hooked up with a guy and Laura says he put it in. Okay. You don't have to believe that or whatever. And she gained weight and boobs grew and she felt pregnant. That I could argue that nothing more than that is needed to give a woman a basis to go to court and say, hey, I think I'm pregnant. I think this guy's a dad. Can we have a test? You might wind up being wrong. And you know the story, Steve. This literally happened to me. I was sued for paternity. I was not the dad. It took 5 minutes and it was no big deal. Take one test.
There was a child that was born out of that.
There was a child.
You know, there was at least a child born.
Not mine. Not my child. Not my child. But look, I didn't blame that girl. And I guess what happened, anyway, I don't want this to be a 12-hour conversation. I have a lot to say on this. I'm going to try and stay focused. I really thought that the issue was as limited and narrow as tell the court why Laura thought she was pregnant. 5 positive pregnancy tests before she filed the petition. And this is where Steve, I hear you. And thank you for letting me talk. I'll let you retort in a minute. I know this is your show anyway. Again, if the standard is, did Laura have any grounds at all, any good faith, reasonable grounds to think she was pregnant? I was focused on that. Clayton's testimony really had nothing to do with whether or not Laura was in fact pregnant. Clayton would have no idea. He would have absolutely no knowledge after he had his what day was it? May 30th, whatever day that happened. Yeah. Whatever day that was.
The hookup, May 20th.
After that day, Clayton knows what happened that night, and he already kindly wrote an email where he said, yeah, there was enough contact that pregnancy was possible, which, you know, everybody misrepresents that and says, oh, it's no big deal. He said it. And thank you for being honest, Clayton. And then after that, what did he have? Laura came over to talk to him one time. He gave her a test. She took it. It was positive. That's the extent of Clayton's knowledge. He has no knowledge of what she did after that. I mean, yes, he has knowledge of her emailing him. He has knowledge of her behavior. That goes to, I think, a completely separate issue. That doesn't go to, did she think she was pregnant or not? I mean, I understand why, if you look at this like a movie script, it all fits together, right? It's all part of a big thing. And it's the theory of this was a fake pregnancy used to manipulate the guy, blah, 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 blah. That was the theory, right? I thought, in my opinion, that the evidence of that was either not relevant at all, or that it was just so, how can I explain it? What if I had 8 hours to cross-examine Clayton? What would I have asked him? Like, did she send you mean emails? Well, yeah. Okay. Does that mean she wasn't pregnant? I mean, I just felt in the time that we had, I had to focus on, you had to prioritize things. Clayton's conspiracy theory about what he thought Laura was really up to me, it was like number 10 on the list of things that were important. So I just, when Mata made it clear that I didn't get anything more than the bare minimum of time, I took my pile of notebooks and I chucked out everything but the absolute most critical things. So I didn't think that Clayton's testimony was going to help or hurt our case in any meaningful way. So I didn't ask him any questions. I would have liked to. I really would have liked to. But, you know, my questions, because I told you I had 5 pages of notes written to ask him, you know, things like, did you lie to Laura about the real estate contracts, right? I can impeach his credibility because he lied to her. He did lie to her. Does that change? Does that change the case? Does that change the pregnancy? Not really. I mean, what are your thoughts, Rachel? I'd love to hear.
So
Rachel, yeah, go ahead, Rachel.
It changes the finder of facts impression of the case, right? You put your client up there. You know she did poorly on the stand.
Sure.
Okay. And I mean, you also really cross-examined her. She didn't talk a lot. You talked more. I mean, if you go back and you watch the trial, and I had the benefit of watching it after I already knew what happened, because I didn't know anything about this case until a few months ago. Way after the trial had happened. I had only seen a headline or two until Steve asked me to watch the trial. She came off very poorly. I don't know if you agree, disagree.
I have a detailed response to that. And I don't want to, and look, your opinion about how she testified is totally valid, Rachel. I mean, it was a tough day for Laura. I mean, it was an awful day. And what you don't know, and I think it's worth mentioning. And I don't know, I'm not trying to like titillate the JFC people who hate Laura so much, but I want to put you in my shoes a little bit on what I went through that morning. Because it was a morning unlike anything I've ever done in 24 years of doing this. Laura was prior to the hearing, because of this issue of Maricini being there, she was,
which we will get to. That's the second thing I wanted to bring up.
She was as close to having a nervous breakdown as I've ever seen a client by a mile. And I actually was at one point, Dr. Medchill is a medical doctor he's an OBGYN, but he also did emergency room care. We were like having him look at her, like, is she medically able to continue? She was shaking, crying hysterically at the fact that Maricini was sitting there. And this is part of my story. Okay. You want to tell your story about, oh, well, Laura sent mean emails to Clayton or whatever. I need you to understand that no litigant should ever be put in a position where they fear for their safety. They have to stare a person in the face that they have a restraining order against. The guy sitting there laughing at her. And all of that happened because Judge Mata ignored the rules. And I'll be specific about what I'm referring to. She was required to set, they call it a pretrial conference, but it's a hearing before trial to talk about anything that needs to be talked about. And Judge Mata's minute entry order setting the hearing said, if anybody wants a pretrial conference, just ask for it. I asked for it the minute I found out that Maricini was going to come after his lawyer lied to me and said he wasn't coming. Okay. I found out at the last minute, oh, he's going to be there. I said, look, we need to talk about how do we do this? There's a restraining order against him from California. Judge Mata had no authority to disregard it, which she did. All I wanted to do was talk about how can I keep Laura and Maricini away from each other so that she doesn't have this breakdown. And Judge Mata thumbed her nose at the rules, denied my request for a hearing, even though the rule said shall be set. Just no, I'm not going to. And she put Laura in a panic position. And I had to try to deal with that on the morning of trial. You guys look like you're not happy with me saying this for some reason. Say what you want. Are you saying, Steve, be honest with me.
No, go ahead, Rachel.
You've done orders of protection before, right?
Sure.
You've done them, of course.
Sure.
You know that the standard is the person has to confront in court the person they claim abuses them. They sit right across from each other.
Yeah, not
a very stressful event.
Not in an interstate. Maricini was not a party to this case. Okay.
But I'm not talking about whether it was legally appropriate. I'm talking about your client being so overwhelmed. You've never seen anything like that. Mm-hmm. You know, she was so stressed by being in the presence of Maricini. I would argue it's because her gig was about to be up, because here's the guy that can prove that this is not the first time she's done it. But even if you disagree with me, people have had to sit next to people that have literally beat them up in order to get a permanent order of protection against them.
Yeah. So, and my response to that is that Laura already did that. She already jumped through those hoops. She already had that fight in San Francisco. And people, again, sort of misrepresent what happened. Maricini agreed to the restraining order initially. People are like, he's a victim. He's a victim. He's a victim. He effing agreed to the restraining order. So I don't know how you label yourself a victim of a false allegation that you agreed to and did not challenge. But then he violated the order and she got it renewed for 5 more years. Okay. All I'm saying to you is, Rachel, you're not wrong about, sometimes people have to go through difficult things, but I think what you're doing is disregarding the fact that there were 20 difficult things happening that morning. And to have this guy be there that had no grounds to be there at all. It just broke her. Okay. So all I'm telling you is the morning was not a good morning. And I think there were justifiable reasons for it. And my conduct that morning, I felt like I was juggling a flaming chainsaw while having my leg bitten by a German Shepherd. That is not how lawyers should be, or litigants should be made to feel. Everyone should feel like we're going to have a nice day in court. Everyone's going to be treated respectfully. It was a circus. It was a circus. And it was a circus because Mata had her father sitting there, and I assume that her sister was watching as well, because the sister follows her on Instagram, Clayton on Instagram. That's how it felt to me, Rachel. I'm just explaining to you how it felt. And I don't know. I can never put myself inside Judge Mata's head. I don't know what her reasons were. I'm telling you how it looked and felt to me and Laura. And Laura was that morning, before we even started, she said to me, I don't know if I can go through with this. I just don't. She saw Maricini in the parking lot and she freaked out. So I did the best that I could to try to put the pieces together to keep it from falling apart. And I didn't do very well, but
wouldn't that be a better reason if you thought Laura was going to be even worse on the stand because of her mental, because of her state of mind? Wouldn't that even be more of a reason to devote more of your time to cross-examining Clayton rather than putting her up on the stand to dig her a deeper hole? Because I mean, you know, at the end of the day, the judge has a tremendous amount of discretion on attorney's fees in these kind of cases. It's significant discretion. It really is, especially when you're talking about findings of reasonableness and unreasonableness in litigation conduct.
Okay.
When you see a litigant up there who looks like they're lying, who looks like they're up to no good, it's not going to help the background of your case. And I think if you had been able to show that Clayton also lied, as you claim you could have, and I don't know, I'm not saying he did, but if you had been able to undermine his credibility, this might have looked more like black hat, rather than white hat, black hat.
I'm going to say something, and I really mean this very respectfully. That sounds like a TV show that you just described, not a real courtroom situation. I mean, I'm not denigrating the hot bench thing. I've never seen it. Okay. But what you're saying is right. If you're talking about, let's make this a movie or a TV show, or make it dramatic. Laura withdrew her petition 6 months before the trial. Rachel, 6 months before the trial, Laura said, "I'm not pregnant anymore." So hang on. I'm sorry.
Fees were on the table. They were put
to that point. Let's read here. This is so good. I really am glad that we're having this discussion. It's ARS 25809G. Okay. And the judge in the Court of Appeals quoted this. This is so good. Here's the part that you're just like not taking this into consideration.
Is this the maintaining or defending the proceeding language?
Yes. Maintaining
part of the proceeding was his request for attorney's fees set forth in the response to the petition.
So
Laura
you're saying
does not get to decide the entirety of the issues that will be presented by framing her petition. You have a response. Clayton asserted a claim for fees.
A claim for fees for the petition, not for going to San Francisco and investigating Maricini's laptop to make some determination about what happened 8 years ago. That is not maintaining or defending a paternity petition, a withdrawn paternity petition. Rachel, I respect your position. I respectfully disagree with it. And yeah, I get that the Court of Appeals is on that other side. I lost that point. I couldn't disagree more with it. You cannot. Arizona has such a narrow view of when attorney's fees are awardable. They have to be specifically permitted by statute. And the statute says maintaining or defending the proceeding, the paternity proceeding, which was moot by then. Let me rephrase it. When you assert
something in response, that's now a claim in the proceeding. It's a proceeding, not a petition. It's a proceeding. The entirety of the thing, including his affirmative request for relief.
That the family court had no jurisdiction over. The family court in Arizona is not an unlimited jurisdiction court. It is a limited jurisdiction court. It's like small claims court.
She invoked the jurisdiction of the court when she filed the petition. She doesn't get to divest the court of jurisdiction by saying, "I'm not pregnant anymore."
She invoked the court's jurisdiction for the purpose of deciding paternity, which ended December 28th. There was no paternity to decide.
Okay. But that's like saying that if somebody files a counterclaim, the minute that someone files their claim, you're just wrong.
No.
Invoked the jurisdiction of the court.
And here's
for the petition.
Right.
Okay.
And
but then Clayton properly invoked the jurisdiction of the court on his request for fees in response thereto. It does not divest the court of jurisdiction. Show me a case that says that once she's no longer pregnant, he can't follow up on his response.
It's not that the court didn't have jurisdiction to decide fees. It's that the question is what fees? Fees for what? Clayton absolutely could have applied for fees incurred if he could prove that they were reasonable between December 12th and December 28th. That was the time that the petition was still pending. And his request for fees to amend his answer to seek fees hadn't even been granted by the time that Laura moved to dismiss. But let me rephrase it this way. Here's how I see it. And you tell me why this is wrong. I read 25809G as saying, I'll paraphrase it, a party can receive attorney's fees for the money that they spent obtaining resolution of the petition.
No, that's wrong, because it completely dismisses the concept of counterclaims, the concept of affirmative relief being requested in response.
Clayton, the Superior Court has no jurisdiction over anything other than Title 25 issues. And this issue of did Laura lie about Maricini's cancer records or whatever is not a Title 25 issue. Clayton did what it's so simple to me, and I don't know why we're butting heads on this. Clayton did not need, if the issue is how much did it cost him to defeat the petition, the answer is not $150,000.
If what you're saying is how much did it cost him to just not have to have paternity established against him, right. I agree with that. He didn't have to proceed, and I completely agree with that. He didn't have to proceed with his request for fees. He could have just gone away and it could have all been over. I agree with you there.
So
but he wasn't obligated to do that.
Yeah, but what you're saying is that somehow there's this magical right to assert a counterclaim for fees and then spend an unlimited amount of money investigating any unrelated things that you want to try to show that Laura filed the thing in bad faith. I don't
think the fact that she's done this before and faked pregnancies before would tend to suggest that she didn't have a good faith belief that she was pregnant. To me, that's very relevant.
So here's where I talked to Steve about this before, and here's where I
David,
feel
real
like
quick, David, real quick, can you move to your left to center yourself more? Yeah, because you're kind of going there.
I'm kind of I'll just turn the camera.
Yeah, there.
Appreciate the direction there.
Yeah.
This is what Steve and I talked about before, and I think where I really disagree with you is I see the paternity petition as I see the paternity action as a small little box unto itself, and the only issue there is paternity and fees related to paternity. Okay, that's how I see it. What I hear you saying, and where I think I disagree, is you see a much bigger legal dispute that needs to be resolved. Does she have a pattern of doing this? Was there emotional distress that Clayton went through? Did Laura defame Clayton? I agree with anybody that says that those are important issues. They're important issues. They're just not issues for the family court. They're just not issues for the family court. They're
I don't think that issue needed to be resolved, but I think saying that you are going to artificially narrow this to only the question of paternity, that it's a deliberately dense reading of the maintaining or defending a proceeding.
Okay, let me flip this around for a minute. Let me flip this around. You know that during the case that Laura said that Clayton had non-consensual intercourse with her, that he asked her to stick it in. She said, no, you can't. And he did. Okay. You understand.
We don't know that. We don't know that he did. We weren't there.
At some point she said that is all.
Okay. Hang on. Wait, just hang on. Yeah. I'm not saying that happened. I'm saying that was an allegation. Okay.
Yeah.
I wasn't there either. I don't have any idea.
Yeah.
But under your reading of 25809G, because Laura made that claim, are you saying that it would have been Can I finish? Are you saying it would have been appropriate? It would have been appropriate for Laura to say, I now need to interview every female who was on The Bachelor and depose them to find out, did Clayton rape them too? Do you think that fits within the family court's jurisdiction?
Of course not.
Of course not. How is how is your argument any different?
Well, because Laura came to court and said, I'm pregnant. We now know she's done this several times before and hasn't been pregnant, it appears, okay? If the issue is a good faith basis for believing she's pregnant, previously faked pregnancies would certainly be at a minimum relevant. You know how low the bar is for relevancy.
I'm going to challenge you on that. I'm going to challenge you on that. And I'm going to throw out another hypothetical. This is exactly the kind of debate that I have with a lot of other people. So hear me out. I'm going to hear you out. Hear me out. Let's entertain a hypothetical for me.
Okay.
Assume for the sake of argument that Laura was pregnant with Clayton's child. Just assume that fact is true. Okay. If Laura was in fact pregnant with Clayton's child, would the fact that she sent fake cancer records to Mike Maricini 8 years earlier change the fact that Laura was pregnant with Clayton's child?
No.
So and if Laura was not pregnant with Clayton's child and she didn't send these records to Maricini, would that be relevant?
But no. Wait, hold on. But you're asking, would it change whether or not she was pregnant? No. But it would change whether or not she had a good faith reason to believe she was pregnant when all of a sudden she was no longer pregnant anymore.
Okay,
hold on, you gotta hear me out. The fact that she has a history of appearing to claim. Have you read her communications with Gillespie and Maricini?
I've not.
Okay.
I've read some of them.
Huge problem, right? In debating this issue. I'm not saying you can't successfully represent her on appeal without reading that. Of course you can. But in terms of this conversation, I mean, from just taking Maricini alone, she claimed to be pregnant for months after having multiple abortions, according to the documents.
Well, okay, so
right?
this is where, hang on.
Hold on. The fact that is so ridiculous certainly tends to suggest, bar for relevance is very low, you know that she was not actually pregnant and didn't believe she was pregnant.
Okay, couple things. This is one of those issues where I don't want to get into a debate over evidence I've never seen. Do I have a document that says it's text messages? Yes. Was I ever provided with the original laptop absolutely required by the disclosure rules? Nope. Was never given that. And I've never seen that evidence. And Rachel, I don't know if you're aware of this. The PDF that Woodnick disclosed to me was totally insecure, such that you could go in and change the wording on any line you wanted. I did. I used it as an example. I went in and just typed some crap and saved the file. So I'm not saying, and Maricini actually filed a bar complaint against me where he said I accused him of fraud because I raised that possibility that somebody might have tampered with this PDF. I never said that he did. I don't know. I never had a chance to investigate that, is all I'm saying. So you're sitting here telling me, well, Laura said this in these messages. You have no idea if those messages are real or not at all. You don't. You think they are, but you don't know. You don't know. And here's ultimately why I'm so strongly disagreeing with you. You clearly believe that witness credibility is relevant in a paternity case. And what I'm saying to you is there is no situation in which a woman could win or lose a paternity case based solely on her testimony, ever.
What do you mean win or lose a paternity case based solely on her testimony? What do you mean by that?
A paternity establishment petition cannot be adjudicated based solely on the testimony of the mom saying, I think I'm pregnant. You agree with me? Yeah.
Absolutely. Okay. However, many issues in a paternity proceeding can turn significantly on credibility, including the parenting time request that your client asked for.
That
if you have someone
the court never ruled
credible,
that the court never ruled on the parenting time that never became an issue because there was no baby to have a parenting.
And the reasonableness of her positions when it comes to attorney's fees.
Okay. Anyway, I maybe we should move on from this topic because you and I are clearly not going to agree on this. The way I see it, Rachel, is there has to be a causal link between the person's bad conduct and the fees that you're claiming that you're looking for.
Do you have case law on that?
Of course.
That there has to be that when you're talking about family law sanctions, because in California it's not the case. You do not have to establish a causal link between specific fees and unreasonable conduct. They have to be related in the sense of I can't go out and spend fees investigating a separate tort claim against another person. But you do not have to establish that the unreasonable conduct caused specific fees.
I will get back to you on case law for that. Okay. Can we move on to the topics? Steve, you're the moderator here.
Yeah. I mean, we're going to have to somehow tighten this up because we just spent 38 minutes on the first question, which was, why didn't you cross-examine Clayton? Now, we did get into other stuff that we were going to hit on later, which was,
Maricini. You were going to ask me about Maricini.
Hold on. So the takeaway from that is not that it was a deliberate decision. It was you had to kind of like figure it out on the fly, and you kind of made a call on the fly, right? That it would be more important to use your time with Laura.
I did not believe and do not believe that Clayton's testimony had anything to do with anything that I needed to prove or disprove. I didn't see the value in it.
Got it.
I wish we could have gotten that in 5 minutes instead. Because we really, I mean, it was almost feel like we're at the trial because we just spent 40 minutes when we're on somewhat of a time crunch. But I mean,
all right, let's move on.
Stuff up. All right, let's just get to the Maricini stuff. Pre-trial, explain the story of everybody is very well aware that you called the Arizona Police Department to have him taken away, arrested for showing up to a trial that he was subpoenaed to be a witness to. Go.
Yeah, he was not subpoenaed. First of all, he was not. Arizona subpoena is not valid to compel a witness to appear from California. Rachel, you disagree?
He was served with a subpoena
from California.
From
California.
Hold on. You say he wasn't subpoenaed. Okay.
Not a valid subpoena.
He was not served with a subpoena that could have been enforced, is what you're saying.
Correct.
If you declined to appear.
Correct.
I understand that you're saying that That's what you're saying. It's cross state lines.
So here, this was part of Mada's bar complaint against me, Steve. I assume that you're very familiar with that. And she said, well, she said, I forget the wording of it, but she said something like, I'm not going to find witness tampering, but it looked like, what did she say? Do you remember what she said specifically?
I don't remember the wording of it. No.
So witness tampering, you can't like threaten a person and say, oh, if you come to trial, I'll burn your house down. I mean, that's, you can't, it's witness intimidation. Can't do that. So what happened behind the scenes, and I assume that you guys are familiar with these facts by now, that I get Woodnick's bare bones disclosure statement where he says Maricini's a witness and he's going to say something about something, which is a violation of our disclosure rules. You have to list a fair summary of what the witness is going to say. Woodnick gave me no details at all. So I find this out and I pick up the phone. I call the only person listed as a contact for Maricini is his lawyer in California. And she goes, I don't know who you are. Maricini's not coming to trial. He's never heard of this case. We have nothing to say to you. I said, great. Can you send me something in writing to confirm that? And she did. This Randy Sue Pollock. Okay. So she sends me an email. She says, he's not coming. Great. I just scratched that off the list. I then, days before the discovery cutoff, get this 2,500 page text message drop from Woodnick saying, oh, Maricini is going to come to trial and talk about these 2,500 text messages that you've never seen before, 2,500 pages of text messages. I immediately then tried to figure out, I went back to Randy Sue Pollock, said, is he coming? She said, we're not going to talk to you, which is not okay under what Rachel, what's the eyebrow?
You think that he has an obligation to talk to you?
Absolutely. Discovery was still open. Discovery was still.
So you had the right to depose him.
Absolutely.
He doesn't have an obligation to voluntarily be interviewed by you. You could have deposed it's like absolutely basic law. You don't have the right to have a third-party witness submit to an interview.
Wow. Stop.
Yeah.
That is exactly the conversation that I had with Randy Sue Pollock. What I said was, I need to depose him or he can talk to me. You can choose to be voluntarily interviewed if you don't want to be deposed. I was willing to do whatever was easiest. She said, you're doing neither. She said, we are not letting you talk to Mike. Okay. That's not okay. And more importantly, the Arizona disclosure rules require substance of the testimony to be disclosed. I'm not supposed to be guessing on what he's going to say. Woodnick gave me nothing. Under the rules, I'm entitled to object and say you just say non-disclosure. This hasn't been.
We got to move on because
well, hang on. I'm giving you
shows up.
Well,
right?
I'm giving you context that there were reasons why I had valid objections to him being there. Non-disclosure being one, absolute non-disclosure.
So Woodnick's failure to disclose was part of the reason that you felt justified in calling the police when he came?
Stop. Can I finish? I'm not even close to finish.
Well, that's part of the problem.
Well, if you let me get there. Let me get there. So I'm behind the scenes having communications with Randy Sue Pollock, trying to get, all I wanted to do was get proper disclosure and an interview with the guy or a deposition. Either you take the pick. They just told me to pound sand. I then tried to talk to Woodnick about it. Guy wouldn't talk to me. I then requested a hearing in front of Mada so this exact issue could be raised, which the rule required her to set. She denied that. I then told Woodnick, we have a problem. We cannot have this guy. We have a valid court order that says he cannot be within 300 feet of Laura. I'm not saying that, and I said this over and over and over in emails to every single participant involved. I said, I want Maricini to be there. If he has a reason to testify, he can come to trial. He cannot be within 300 feet of Laura, ever, period. And they just said, go F yourself. So Laura that morning said to me, if he's here and is within 300 feet of me, she goes, I'm not going to stay at the trial. I'm just going to leave. So I said, what can I do? She said, I want the police to come and enforce this order. I said, okay, I'll try. So I tried every single possible thing. I called court security. I said, look, we have a court order. Here's a copy of it. Here's federal law. The Violence Against Women Act said the order shall be enforced, full faith and credit. Mada had no authority to disregard it, which she did. And I just tried to ask the police to enforce a facial court order. They then talked to Mada. She says, don't do it. I still maintain, I think that was illegal. I think that was a crime, but people don't agree with me.
Okay.
So look, I never said the guy can't testify. I just said he can't be within 300 feet of Laura. So
how is he going to testify if he can't be within 300 feet of her?
Let Laura leave the room. Let him be in a different room. Let him. Why couldn't you have just asked the judge to let her leave? Rather than When did I get a chance to do any of that?
I'm asking you.
That is, well, if you go back and look at what I made an opening statement to the court at the beginning of the trial, raising these exact issues, and Mata just didn't want to entertain any of it. Okay. If she had given me options, I would have considered them. We just didn't. We did the best we could with what we had. Asking the police to enforce a valid court order to me is a not controversial thing. I mean, I just should have ignored it. I just should have said, sorry, Laura, California court orders don't apply in Arizona, even though there's a federal law that says they do. I don't know what you
should have said that. But I think you might have said to your client, we're not going to call the police on him when he's here to testify. And we've known for months that or weeks, I don't know what it is, that he's coming to testify.
Days.
At that point, it was days. Okay,
yes.
So she should have been prepped that he would be there and not have the police called when he came in.
Okay, I just agree to disagree. There's nothing. Anyway, we'll just see it. We see that differently. And again, Mata did what she did, and so far nobody cares about my arguments. That's not really part of our appeal. I understand it's part of the bigger picture, but
just as a lay person, we did have security officers there. We did have police officers. What did you think was going to happen? What did she think was going to happen? He was going to jump over benches and attack her? What?
Steve,
let's just be honest here.
Steve,
what was going to happen?
First of all, you're asking a question that should be answered by Laura, not by me. But all I can say about that is she had a court order that said this man is not allowed to be this close to her. Why did she want the court order enforced? Why wouldn't she? Why should she have to give up her rights because we just don't like her very much? It's anyway. I don't agree at all with what you guys are saying, and you don't agree with what I'm saying. So I just didn't want Maricini to be there and intimidate Laura and scare her just by looking at her. I don't care, Steve, if it was just bringing back bad memories. Okay. Laura should not have to suffer through that just because Clayton was on a TV show. Okay. That doesn't give him some superior right to make Laura feel the way that she felt.
Nobody's claiming that it does.
Really?
Yes. Really.
Okay. All right. We're moving on to the next question. We're not going to get very far with that. So,
okay. So I guess we'll move on from the trial. We know what the trial's decision was. And then, obviously we'll just get to the most recent thing, which was the Court of Appeals denial. And you lost again. You kept your streak alive of losing in this case.
Which, by the way, you said there was 0% chance.
0% chance. No chance in hell that Clayton was going to win this appeal.
What lawyer ever says that? If they're being taken,
I don't. Did I say 0%?
Yes, I played the clip. That's what I tweeted out. I have the clip.
Well, you're welcome that I gave you that's such an easy way to roast me.
Yeah,
guys, look.
Yeah.
But why did you say it when you? My problem was
I believed it. Because
I have no problem with you believing your client was going to win.
Or I think I'm going to win.
It's the presentation of it when you made it seem like there was 0% chance when you've been in many litigations. It's a possibility you might not win something. I know you're projecting confidence in winning, but it came across horrible, and then we ended up being right in the end.
Well, that makes it that much sweeter at this point, but it ain't over yet, Steve. It ain't over yet. We may still get a 100% victory for Laura. We don't know. So I actually could be right. I actually could wind up being right. We just don't know yet.
We're talking about the appeal part. We're talking about the appeal.
There's no chance you lost this appeal.
Yeah.
And that appeal has been lost. Right now you elevate it. Obviously, something could change. I would never say there is a 0% chance that you will have this.
Rachel, here can I offer you like a cookie or something? What do you want me to say? What do you want me to say?
Not say 0%. Just say you're confident in our case. We like our case. We've made a strong argument. I really like my appeal, and I think we have a good chance to win this thing. But to degrade everybody who says you're going to lose and everybody who says who ended up all being right, to just do it the way you did it. I'm just saying you could have taken a more tactful approach. You don't agree with that?
I hear what you're saying. Steve, we're living in weird times, man. I've been drinking too much Trump Kool-Aid, which again, I don't like Donald Trump. This is sarcasm. Does Donald Trump ever say, "Oh, I'm going to lose the election," or "I'm going to lose this criminal case"?
It's why a lot of people don't like him.
That is part of the sort of
trend
of society that I think a lot of us are are not happy with where it's going, right? That instead of having reasonable conversation saying, I'm really confident in this appeal, I feel like we're going to win it, we're taking the Trumpian approach and saying 100% victory. I mean, that's why the world is going where it is. Why contribute to that?
I give you my unconditional apology for using bombastic language that was just too confident. I shouldn't have said that. Can we move on? Okay. Yeah. It's not really what we're here to talk about. I don't think.
Yeah. Okay. So the Court of Appeals denial. So now we just get to, what did you think was wrong with the Court of Appeals opinion? Why do you feel you were right in your appeal?
Absolutely.
And why do you think you will be successful in, if you are going to do, the latest news is, maybe you're going to break it here on this podcast, you're thinking of doing reconsideration, but even if you don't, you're going to go to the Arizona Supreme Court and then the U.S. Supreme Court. So why do you think your case?
Let's get into that. Let's get into that. So page 4, you said you had the ruling. We don't really need, I mean, this stuff is so dry. People that aren't lawyers.
You want the Court of Appeals decision?
No, you don't need to. Let me, if we need to refer to it, you can pull it up. I've obviously got it right here.
Yeah.
I'm just letting you know that on page 4, the court shoots down my Rule 26 argument and basically just bought into what Clayton said, that Rule 26 was not the basis for sanctions. Therefore, we don't have to talk about it. That's essentially the entire analysis, right?
Yeah.
There
were alternative bases for
right. And I cited case law. Holgate versus Baldwin was my favorite one, but there were cases that I cited that basically said, and I'll paraphrase, that the existence of alternative grounds for punishing a person who violates Rule 11 or Rule 26 doesn't allow a court to disregard the safe harbor provision of the rule. A person has to be allowed to withdraw an offending pleading before they're punished for that pleading.
Only under Rule 26.
No, Rachel.
Read your case.
No, you're incorrect.
Take me to Colgate. Pull it up.
Are we really getting that detailed?
I've read every single one, and not one of them says that you cannot punish conduct that could be punished under Rule 26 under an alternative theory of sanctions.
That is exactly what Holgate, or was it? It might have been Rainbow. Look, I'm not going to get into that level. Read the pleadings. You don't agree with it. You don't agree with it. But I'm telling you, the case law that I cited says that this analysis, you cannot simply disregard the safe harbor. When did Laura get her safe harbor, Rachel? When did she get her safe? You agree that there is a safe harbor.
She wasn't entitled to a safe harbor prior to being sanctioned under 25, I don't know, 809, I'm forgetting the number now, G, right? There is no safe harbor under the statutes that both Judge Mata and the Court of Appeals agreed she was sanctioned or Clayton was awarded fees under.
Okay, but do you agree with me? Do you admit that in Woodnick's first filing, he asked the court to grant Rule 26 sanctions? Do you agree with me with that?
I agree. At some point, he asked for Rule 26 sanctions.
It was in the very first thing. I don't mind telling you, I have that part memorized.
Okay. Yeah, I don't have any reason to agree or disagree with that.
And do you agree with me that?
Well, wait a minute. Hold on. But fees had been requested prior to that by Clayton in his response to the petition.
In the same thing, he requested sanctions and fees.
Clayton's handwritten response.
Yeah.
Well, he didn't have any fees.
But there had been a request for fees pursuant to the alternative statutes prior to any Rule 26 motion being filed.
Which he didn't incur, but yes, I agree with that.
Okay, so it wasn't, Rule 26 was not the first time that any of these statutes were invoked.
Yeah, okay, hang on. You're getting a far afield here. You need to follow me.
I'm following you.
There was a threat for sanctions under Rule 26. You agree with me?
Yes.
Yes, there was. Of course there was. Yeah. And that threat was in fact followed through on. There was a motion for sanctions filed, correct?
Well, when you say the threat was followed through on, yes, a motion for sanctions was filed and then withdrawn. I agree.
When was that withdrawn?
You tell me. February, January? When was it withdrawn?
April. I think it was April.
April. Okay.
I didn't get hired until March 25th.
Okay.
Okay. So it was months later that Woodnick finally withdrew this. Okay. The issue that you are missing, and I just totally reject where you're coming from. I'm sorry. I respectfully do. There was a threat of Rule 26 sanctions that invoked the procedure of the rule, and the filing of the motion invoked the procedure of the rule. Laura had a right to withdraw the offending pleading. She was not given that right. If she withdrew the offending pleading, what are we litigating?
What about the other bases for sanctions?
Okay. I don't know what part of this you're missing. Under Rule 26, if a person accuses you of filing a pleading that offends the rule, you have a right to fix it.
Before sanctions can be awarded under that statute.
Under any statute.
But show me a case that says that, because your cases don't. I've read them all now.
No, you need to read them again. You're incorrect. You're in courts.
Can you just give me a quote from Holgate. Just give me a quote from Holgate that says.
Can we have do you want me to have like a break and come back to this? I'll be happy.
Yeah, if she wants a quote and you can get one, yeah, let's just pause it. Let me pause it.
Let's just pause it and get me one.
Yeah, let's pause it. We'll pause it real quick and then come back when you have found it. So pause. Oh. All right, we're back. So we have pulled up the case. We pulled up the Court of Appeals, page 30. Here we go. So this is this is the case that she told you to get a quote or.
Yeah. So I believe that there are many. Rachel believes that I'm either wrong or whatever. This is what I'm trying to walk you through where I'm getting my argument from. Okay. And the Rainbow case involved a Rule 11 violation, which is the same as Rule 26. And in this case, they did not follow the correct procedure, and the court sanctioned the person anyway, because the judge said, well, I just have inherent authority. I could do it on my own. So it doesn't,
That's not true. It was not under the court's inherent authority. It was under the court's retroactive conversion of the Rule 26 motion to Rule 11 to a sua sponte.
Right.
Rule 11. It was not under the court's inherent authority to control the proceedings. Different issue.
I'm not making a distinction between those two. I see those as the same thing. Okay. I understand you see it as something different. I see that as not a relevant distinction. Read the. How can it
not be relevant though? The whole point is there was no other basis other than Rule 11 for the sanctions in that case.
Can you hang on? Can you hang on for just a second here?
Go ahead.
The latter part of that block quoted paragraph, Steve, if you want to flip down to the next page.
Yeah.
So what the court is saying here. So again, this dealt with a filing of a frivolous pleading, a party asking for sanctions, and then they didn't follow the rule. Okay. That is structurally what happened in our case. Same exact thing. And the court.
No, it's not, because it was not only requests under Rule 26 in our case. But go ahead.
Okay. Lord. In the Rainbow case, there was a violation of the rule. There was a threat for sanctions. There was a motion filed that didn't comply with the procedures. The court granted sanctions anyway and said, well, I could do it on my own. Under the rule, the court can sanction without a motion. Okay. And the Ninth Circuit said you can't do it that way because it would render the safe harbor meaningless to permit a party's non-compliant motion to be converted automatically into a court-initiated motion, thereby escaping the service requirement. Yeah. What they are saying is you can't do an end run around the safe harbor by using some other way of getting to the same place. You have to.
That's not what they're saying at all.
What are they saying?
What they're saying is the court cannot say, you know what? Instead of calling this a Rule 11 motion filed by you, we're going to call it a Rule 11 motion that I initiated sua sponte.
Correct.
Right? Which is completely different than what happened in this case. Because in this case, there were other proper requests for sanctions under different authority than Rule 26.
Okay. All I'm saying to you is Rachel, what
is your response to what she just said?
What is your response to that?
You are ignoring you are pretending. Wait, if you want me to stay on this, you need to let me have fair opportunity to answer. Okay,
David, of 58 minutes, you've probably talked for 42 of them. I mean, come on, man.
Okay, guys. Rachel, the problem is you are pretending that a Rule 26 threat was never made, and you are pretending that a Rule 26 motion was never filed. You are ignoring those facts, and you cannot do that because
I'm not. I'm just saying that sanctions were never awarded under Rule 26.
Brilliant.
They were awarded under different statutes.
Brilliant. But are we going to pretend the Rule 26 threat didn't happen? Because that threat gave Laura the right to withdraw her petition without punishment.
Under Rule 26.
Right.
Okay. So wait a minute, hold on. This is important though, because the only case I saw cited in either brief that actually deals with the issue of sanctioning that conduct under separate authority was in Woodnick's brief. Hold on.
Let me,
I got the
Rachel,
case somewhere.
hang on. I'm not going to debate Woodnick's brief with you right now. That's just not the level that I was prepared to go into right now. I'm just not.
Right, but you've said in your, hold on, you said, and I highlighted this part of your blog, I cited plenty of legal authority
Right.
for the idea that a Rule 26 violation cannot be punished under other authority.
Oh, I know what case you're going to talk. I know what you're going to talk about. I know what you're going to do.
But, you said I've cited plenty of legal authority, and you said the Court of Appeal just ignored that authority.
Right.
What is that authority?
You're looking right at it.
But there's no other authority
Okay, Rachel.
at issue in Radcliffe.
Oh,
There's
God.
only the Rule 11.
Listen, you got to let me answer.
Okay.
Follow me through on this. Follow me through. Okay, let's just have a little yes or no thing here. Do you agree with me that under Rule 26, Laura had a right to withdraw the offending pleading? Did she have that right or not?
Before she could be sanctioned under Rule 26, I agree.
Okay. The other authority that you are so focused on, like 809G, what does that allow punishment for?
Unreasonable litigation conduct.
Unreasonable.
Shifting fees for other.
It allows for fees for unreasonable litigation conduct. What unreasonable litigation conduct would have happened if Laura had been allowed to withdraw her petition as Rule 26 gave her the right to do?
But what I'm telling you is filing a petition when you don't really believe you're pregnant is unreasonable litigation conduct.
Great.
That can be punished separately. Hold on, there's other authority other than Rule 11/26 under which that can be punished. And that is the theory, right? That was what was at issue in that case, which it sounds like you remember the name better than I do. It was actually cited.
It was a case where somebody was sanctioned like $1,000.
Maybe.
That's what that was.
Who cares? It was the court actually saying, to be sure, you can still sanction under other authority.
Yeah.
Without giving the safe harbor.
If we were talking about sanctioning Laura under any authority for her conduct between August 1st, when she filed the petition, and December 28th, when she withdrew it, if that was the unreasonable litigation conduct that you claim occurred, I would agree with you. But that's not what happened. What happened was Woodnick threatened her and she withdrew. Have you ever sent or received a Rule 11 threat, Rachel?
I have sent them. I've never received one.
Okay. I've sent and received a few. Okay. And tell me if I'm wrong about this. Every single one of those threats follows the same pattern. Dear Rachel, I've read your pleading that was filed. I have concerns that it is not consistent with Rule 11. Here are my concerns. Please review these authorities. Here's what the problem is. And if I demand that you withdraw your pleading within the next 10 days, if you fail to do so, then I will seek sanctions. That's generally the format, right?
I will seek sanctions under this rule. Yes.
Right. Have you ever seen a threat that said, Rachel, you violated the rule. I demand that you withdraw your pleading, and I'm not going to let you withdraw your pleading. She was punished for conduct that the court wouldn't forced her to engage in. Laura had no intention of continuing this litigation past December 28th.
Okay. But
and then she was sanctioned for unreasonable conduct past December 28th. That makes no sense.
All of these arguments go to, and I told Steve this, what I think is your best common sense argument, which is that really what Clayton should have done was just given up after December 28th.
No. This is where
there's no legal authority supporting your position, because you just conceded a second ago that you would agree with me if she had been sanctioned for the litigation conduct between August and December under different authority. But that wouldn't be the case if you really believed that Rule 11/26 provided a safe harbor against any sanctions related to the filing of a frivolous, not frivolous, but the improper filing of a pleading.
Because I wouldn't call it sanctions. What I'm saying to you is, my view of the law is, if Laura engaged in sanctionable conduct, a violation of Rule 26, we address that under Rule 26, right?
No, wait, we addressed that? What do you mean? You didn't address it. Was not addressed under Rule 26.
Hang on. That is the legal argument that I made in the second part of my opening brief that you said was after Rainbow, the next section where I said that she was protected under, for the safe harbor applied to relief under other authority. And what I was saying is, if you read the arguments that I made there's a general rule in Arizona that when a statute provides a remedy for a wrong, that remedy is exclusive. Okay. So you can't say you violated Rule 26 because you signed a pleading that wasn't true, which Rule 26 says you are not allowed to do, right? You can't use that violation for punishment under some other authority without following the Rule 26 process. But
the Court of Appeals disagreed with you on that point as well.
It did.
It is not an exclusive remedy.
Okay.
There's another remedy for unreasonable litigation conduct, which within it can include the filing of a pleading that is not reasonable. But the court said it was more than that. There was a host of unreasonable things that were done.
The court refused to give Laura the safe harbor she was entitled to, and then it punished her for unreasonable conduct after it refused to let her drop the petition. If you think that makes sense, then you and I are just cut from different cloth. Okay. I've done a lot of litigation where people have engaged in sanctionable conduct, and I have asked for sanctions and tried to get punishment through any means possible. And I've never seen a court disregard the safe harbor provision and say, I'm just going to sanction you $150,000 for doing something that was a violation of Rule 11, but I'm just going to call it something else. Okay,
so you've sought sanctions under other statutes, no mention of Rule 26. And the court has said, wait a minute, hold on. That could also be a violation of Rule 26. Therefore, I'm invoking a safe harbor with respect to a rule that doesn't have a statutory safe harbor.
You're not listening. Steve,
I'm totally listening.
We got to move on. We got to move on from that. I've asked for sanctions in cases, and courts just go, no. If a person withdraws a pleading, we're done.
Okay.
Because that's the safe harbor. That's what they give. That the safe harbor gives them a reward for doing the right thing. Laura never got that reward.
Under Rule 26, though, is the whole point.
If there was no paternity petition pending, how could she have acted unreasonably in litigating the petition?
Okay. There wasn't any paternity when she tried to withdraw it. There were other issues before the court.
Oh, for God's sake. Okay, we're talking in circles. We're talking in circles.
What about the fact, so let me just stop you there. What about the fact that she filed a request for mediation when she knew she was no longer pregnant?
When Clayton didn't have a lawyer.
I'm just asking you, what about that? Was that reasonable litigation conduct? What if Clayton consulted a lawyer at that point? Because he didn't have to go to mediation.
What fees did that cause?
I'm asking you, what if he had consulted a lawyer at that point? Would that count?
What fees did that cause? Sorry, my phone's ringing.
No. I'm asking you. Right? Because we disagree on the causal connection requirement. If he consulted an attorney because of her request for mediation, the court found that she filed. I'm asking you if you asked me to engage in a hypothetical, I'm asking you to engage in a hypothetical. Okay. If he consulted an attorney because a request for mediation had been filed and she filed that knowing she was no longer pregnant, could she be sanctioned for that?
Not without following Rule 26. If that's the violation, could he ask for fees? Could he ask for fees for unreasonable litigation conduct during that window when this unreasonable conduct was happening? Sure. Of course he could. I've never said that was not the case. Well, I still maintain if the unreasonable litigation conduct is a Rule 26 violation, we resolve it under Rule 26. If the unreasonable litigation conduct was something else, then we don't look at Rule 26. I agree with you completely.
Okay, but what if it could be a Rule 26 violation or something else? The same conduct can violate multiple rules.
No. So Rule 26 deals with signing pleadings. Okay. It doesn't deal with conduct. It does not deal with conduct.
But signing a pleading is conduct.
What I'm saying to you is you can engage in unreasonable conduct that isn't signing a pleading.
I agree with you completely.
Great.
Yeah.
And if that happened, and if Laura engaged in unreasonable conduct that wasn't signing a pleading, and that conduct caused Clayton to incur fees, I agree with you. You could recover that under something else. Absolutely.
Okay, so
yes.
anytime, so what you're saying is anytime you sign a pleading, that cannot fall under any other sanctionable statute or fee statute, sanctions or fees, right? Because that's another point the Court of Appeals raised. It can't be sanctioned or because it could fall under Rule 26.
It does fall under Rule 26. And if you sign a pleading in violation of Rule 26, you are answerable under Rule 26 if the process is followed.
Right. But what if you decline to bring a Rule 26 motion and you instead seek fees or sanctions under Rule 25, 809?
Actually, you know what's awesome that you asked that? Because when Steve and I were talking about doing this, I had a copyright infringement case in Massachusetts a few years ago, and the plaintiff was a lawyer. Why are you laughing?
Because Steve started wiping his face.
Anyway, I had a copyright infringement case in Massachusetts. It was called Small Justice. Small Justice was the name of the LLC. But anyway, it was a weird, and it was a frivolous, and it was a Rule 11 violation that the guy did. But we didn't seek sanctions under Rule 11. We didn't go down that road. We litigated the copyright issue. We won, and we applied for fees. And the court awarded fees. And we appealed, and we won the fees on the appeal. So I agree with you, but I put that in my brief. I put that in I think it was my opening brief or the reply, that Clayton had a choice here. He could have done this a couple of different ways, but the thing that he actually did was try to use the Rule 26 process, but he did it wrong. And then the MATA screwed up by not allowing Laura to invoke the safe harbor.
Right, but the safe harbor would have only shielded her against sanctions under Rule 26. You have yet to point to any authority which says, oh, you had another request for fees pending under separate authority. The Rule 26 safe harbor protects you from sanctions under that statute as well. Right. I'm saying show me the authority, because the only authority I've seen which even touches on that subject from either brief finds the other way. It cuts against you.
Okay, Steve, can we move on? Because we're not going to get. I don't agree with you, Rachel. I don't agree with you. I respectfully disagree. And so far, the court says I'm wrong. But let's keep going. I just think
that was actually something that I wanted to bring up. I mean, you have argued your side on this. Like I said, most of this we can agree that in an hour and 12 minutes, it's been mostly you talking. But and you're obviously stating your case and you want to defend your side, but we do have a ruling from the Court of Appeals which says your argument is not grounded in law or fact. So clearly Rachel's not the only person sitting here that disagrees with your arguments. Yep. Court of Appeals shot you down. So it's like, why do we have to, every time Rachel says something, you're just like, oh, you're not listening. It's just I don't get it. She is listening. She's listening to every word you say. And she's presenting something, and then you come back and shake your head and sigh.
Because we are miles apart on some really basic fundamental things, and I just can't comprehend.
Right, but 3 appellate justices are on my side of the miles apart, right? Is what I'm saying, and you can't conceive of how we could all think this.
Yeah, Rachel, your position, and we've already talked about this, and so I guess I'll just repeat it again. I don't. That's why I don't want to waste time, Steve. We have other things to get to, but your position is we just ignore Rule 26, even though there was a Rule 26 threat, even though there was a Rule 26 motion, and even though there is a Rule 26 safe harbor, we're just going to ignore all of that, right? We're going to ignore all of it. We're going to pretend it's not real, doesn't exist, doesn't matter, and because there's other ways to get sanctions. But the problem in your argument, the flaw as I see it, is you're not putting any weight to the fact that the safe harbor gave Laura a right to stop the case and avoid punishment up until that point. Okay. You're just ignoring that. You have show me authority that says a judge can litigate a paternity petition where there is no child.
Oh no, I'm showing you authority, which is Karen Cheney, saying that exercising your right to the safe harbor and withdrawing the offending pleading under Rule 11, right, does not mean you're protected from all sanctions.
Right. For other
can be imposed under other statutes or the court's inherent authority, which, by the way, you said was the same, which I disagree with, and so does the Ninth Circuit. But it says, because none of these alternative avenues were pursued.
That's dicta. You're reading dicta in a case where that didn't happen.
But you have but yes, I'm reading dicta, although it's very express dicta. But
No,
you have no authority whatsoever for your position, where the court is actually holding, you know what? I understand this could be sanctioned under Rule 11. However, the court tried to sanction it under, in this one, 28 USC 1927. I'm going to go ahead and find the safe harbor.
Did you read my discussion of 1927?
It's a different statute. I'm saying this is the closest that comes.
No,
it's the closest that it comes.
I know,
because
but
you don't have any authority supporting your position. And so dicta for this case, which is not entirely on point, I agree with you. It's not a perfect analog.
My authority, Rachel, is that if Rule 26 gave Laura a right to stop the unreasonable conduct that Clayton believes was happening, that she had a right to stop it. She had a right to say, I waved the white flag for whatever reason, either because she admitted that the whole thing wasn't true, or just because she miscarried. Whatever the reason, she had a right to end the litigation under that safe harbor, and she was not given that right.
So if I file a copyright claim against Steve, okay, and then he files a counterclaim against me that I actually infringed his copyright, or whatever, that I interfered with his business relations. No, stop. And he has a request for affirmative relief. And then he gives me notice, he serves whichever the applicable rule would be for, Rule 11 violation. And I say, okay, I'm withdrawing my pleading. That does not give me a right to stop the case.
Of course. I agree with you. But if your counterclaim was that the claim that was originally brought and then withdrawn was fraudulent, you win. You've won. You won. When Laura withdrew her petition and said, I'm not pregnant anymore, whatever Clayton's counterclaim was, he won. At that point, there was nothing to fight anymore. The issue that you guys wanted him to fight was, did she lie from the beginning? Was the whole thing a abusive process? Mata had no authority. She had no subject matter jurisdiction to decide a civil tort claim like that. It's a jury trial.
We just disagree that it's a civil tort claim. That's all.
Okay.
So to that point, you know the date better than I do. When did Laura say, not pregnant? There's no pregnancy here anymore. December.
When did she 14th? Say it? When did she say it? The first pronouncement of that fact was in her motion to dismiss on December 28th, which literally says petitioner is no longer pregnant.
Okay.
But way before my time, way before I was there.
Way before you're there. The hookup happened, and this is me, layperson again. Hookup happened, we know, May 20th. Says found out 11 days later she was pregnant. That's kind of random, but anyway. May 20th hookup, December 28th.
Can I give you just a little, the timing, the 11 days?
Yeah.
In my paternity case, when I got sued, it was 5 days. Okay. 5 days. 5 days between the hookup and when she said she was pregnant. But go ahead.
May 20th hookup, December 28th, she says no longer pregnant.
Right.
And I think you have stated, hey, why didn't Clayton, basically you're saying, why didn't Clayton drop the case in December? Like when she said this, hey, there's no baby here anymore. Why are we even debating this? Why is this a case? Right? Right. Okay. That is, doing my math correctly, that's 7 months after this hookup took place. Okay. This man was disparaged by this woman from the second she went to the Sun in September. And December 28th minus, and then on November 2nd, in a hearing, she stood up in front of a judge and said, Judge, can I show Clayton my belly? I am 24 weeks pregnant. It is Clayton's. Here's my belly.
Right.
So on December 28th, when she says no longer pregnant, wouldn't you, as the man in this situation who has been disparaged by her for 7 months, wouldn't you just be like, well, I'm not just going to dismiss this because you literally dragged me through the mud for 7 months. And if you are no longer pregnant now on December 28th, this isn't a 6 or 8 week pregnancy where you had some blood dribble out in a toilet. Sorry for the graphic nature. At 7 months, where are these children?
Okay. You ready?
Where are they, David? This is the one thing that I think everybody wants to know.
Okay.
How in the world was she 7 months pregnant and on November 2nd stood up with a belly and showed everybody, I've got a giant belly. I'm pregnant with twins. They are Claytons. If she says she miscarried the next day on November 3rd, she's still 6 months pregnant.
Okay.
Where are these children?
All right. Can we take this one step at a time?
Yeah.
You and I talked about this before. And the issue that I have with what you just said, hang on, everyone's
my dog's
elsewhere.
working. Yeah, it's just working.
What you're making is a very passionate plea that Laura did all these things and disparaged Clayton for months and months and months.
Yes.
And you have never heard me say that I think there should be no recourse for that. You've never heard me say that. You've never heard me say that that's okay. You've never heard me say that that's not actionable. What I've said is that's not an issue for family court. That is a defamation claim or something similar. Abusive process would fit this perfectly. And Clayton could bring those claims, still could. The statutes run on defamation, but abusive process has a 2-year statute. He could still sue Laura. I mean, at this point, he has a judgment. You can't recover twice for the same thing. But what he could have done, and what I think he should have done, if everything you're saying is true, if every word of what you just said is true, the remedy and the recourse would have been when Laura moved to dismiss the family law case, you go, fine, we're done with family court. Bye. Here's your summons.
I'm going to file a civil suit.
Here's your complaint and summons to appear in civil court where you have a jury trial right and more procedural protections than what family court gives you. And he could have gone through that process and every single argument I'm making would go out the window. If you read the federal version of Rule 11, the committee comment notes under that literally say, and Rachel, I'm giving you a freebie here. The comment notes say, Rule 11 safe harbor does not protect against malicious prosecution claims. Of course. So everything I'm saying, and I've said that from day one, I've never tried to say that you can't be sued for engaging in the safe harbor doesn't protect you. It just gives you a right to stop. It gives you a right to end the harm that you're allegedly causing and limit the damages. Okay. And Laura was never given that right to stop what allegedly was causing the damages. That's where, Rachel, that fact is why you and I are butting heads so strongly, because I don't understand how you think it's okay for a court to force a person to involuntarily litigate a claim and then punish them for involuntarily litigating the claim. That is madness to me.
Yeah, well, we just disagree because I don't believe that Rule 26 gives you an absolute right to stop and be free of sanctions under any authority if you've engaged in other offending conduct.
You're completely correct, with a couple of caveats and contingencies. Like I said, if Laura engaged in unreasonable litigation conduct between August 1 and December 28th, and that unreasonable litigation conduct caused Clayton to incur fees, could he recover that? Absolutely. Absolutely he can. Yes. Okay. But not if the unreasonable conduct is signing a pleading in violation of Rule 26. That's where
we disagree.
Okay.
Yeah.
All right, let's move on, Steve. We got to
Can we get an answer to where the kids are?
Oh, so my take on that, my understanding of that is Laura miscarried earlier and just didn't know it. She miscarried probably, maybe even possibly before the case was filed. And
before the case was filed?
Did you not know that?
That she might have miscarried in July?
I believe that's what everyone is now saying.
That's what our expert.
How do you explain the
then
baby
why
bump?
do you do this and say, can I show my belly? How would she have a belly in November if she miscarried in July or August?
Have you seen the pictures of her body? That belly was real. The belly was real. What medical explanation exists for it? Our expert had no problem saying, I've seen that a million times. It's not common, but it happens.
Yeah.
Steve, I'm just telling you, man.
I know.
Yeah,
nobody thinks Medchill was worth a damn. He was awful up there on the trial.
This is my bigger question, right? This is a woman who claimed she had an extremely high risk pregnancy and was pregnant with twins.
Yes.
She never sees a doctor?
She did see a doctor.
When?
Mom doc on November 14th, and she goes in and that's when the pregnancy was confirmed to be over.
Yeah.
November 14th. She claims to have conceived in May. And by the way, all the documents or all the things where she says like, well, they asked me what date I conceived. Nobody asks you what date you conceived. They ask you the date of your last menstrual period. But regardless of that, she claims to have found out she was pregnant. What is it? The very end of May, Steve? or very
May 20th was the hookup.
Okay.
And then June, it was either May 31st or June 1st where she said to Clayton,
May
"Hey, I'm ready.
31st.
We need to meet."
That is almost 6 months she went. May 31st to November 14th. There is no woman with a high-risk pregnancy with access to medical care who does not see a doctor for the first 6 months of her pregnancy.
If they're keeping their child, you're right. And if they're not keeping their child, you're wrong. Women don't go get sonograms when they're going to have an abortion. That's just, I
agree with you, but how is she going to have an abortion 6 months later? She's going to have a 6-month abortion? No, I don't think so.
Clearly the pregnancy failed way earlier than we now know. Like it's easy for us to look back at this. At the time Laura filed the petition on August 1st, which is really the starting point of this whole problem, she didn't know what her body was going to do in September, October, November. That hadn't happened yet.
Okay, but you're saying that she was never intending to keep the pregnancy.
No, I didn't say she was never intending to. That was the beginning of.
Just froze.
Did I? I froze?
You just froze. Say that again, Rachel. And then you just froze.
Right. So I just said, how does she not see a doctor for 6 months? And you say, well, that's when someone is not intending to keep a pregnancy. Okay. But we know she never went in for an abortion. And if she really believed she was pregnant, hold on. If she really believed she was pregnant in September, that you're past the window. In October.
Look, at some point.
But I want an answer to that. How does somebody who has a high risk pregnancy not see a doctor until the 6th month of pregnancy?
All I can tell you is, again, I wasn't her lawyer at the time. All I know is all these things were already done deals when I came along. Okay. So I wasn't there when all this occurred. I don't know. I didn't have conversations with her when this happened. I didn't know her then. I came involved months later. So looking back, all I can tell you is medically, our expert said nothing about this looks weird to him. I understand it looks weird to you because you started from the presumption that she was never pregnant to begin with. She's a liar because Maricini and Gillespie say so. I don't have any knowledge of any of that. Okay. I came involved way after all this happened. And all I know is our doctor says she probably miscarried earlier and some of the placenta stayed inside of her body, which is why she still was testing positive for pregnancy, which I think the last positive one was mid-September. Steve, you probably know. Mid-September. There was the 102 HCG, which then she changed it and made it higher and sent that to Dave.
Middle of October, I believe it was.
I don't think that's right.
Yeah, the 102 was in October for sure.
The 102 was in October.
Yeah.
Anyway, regardless.
So she still hadn't sought any medical care by that point.
Well.
And your explanation for that is, well, you don't do that when you're going to terminate a pregnancy. But she was way past the point of being able to terminate at that point.
If you're right about that, I don't know. My wife has never been pregnant. I don't have any children. So I don't know what the criteria are for when you're allowed to terminate or whatever. Look, all I can tell you is my knowledge of the facts of when the pregnancy ended based on our expert testimony and his position, probably before the case was even filed, and Laura just didn't realize it. Okay. So, but again, ultimately, what does that have to do with the outcome of this case? Did all of that cause $150,000 in fees to be needed, to be necessary, to be reasonable? I don't see it. Even if everything you're saying is right, Rachel, even if your entire theory is correct, that the whole thing was a sham from day one, she stopped it on December 28th. And again, like I've already said, Clayton could sue her for the conduct that she committed during that time period, separate and apart from anything in family court.
Okay, but she didn't stop it on December 28th.
She did. Well, she tried to.
Right. Yes, she was going to dismiss with prejudice, right? But now her claim is that everything before that, right? She just stopped. She was basically going to stop the case, but then when she found out she wasn't pregnant, but instead she used the process of the court to request mediation. Why?
Which was denied. Why
didn't the court sanction her for that?
Because there were no fees incurred from that.
And you're saying, I mean, that's the question, right? Didn't Clayton incur some fees? Couldn't he have incurred some fees before he had counsel appear for him?
If you're right, Rachel, then the outcome here is the judgment for 150 gets reversed and remanded and sent back for a recalculation of what fees were incurred from the unreasonable conduct while it was occurring.
But I don't think you made a causation argument in your appellate brief.
Well, look,
I didn't see one. You didn't challenge that issue on appeal. That wasn't before the court.
I totally disagree. But look, can we move on from something? I mean, we're just going in circles. I mean, like I've got Steve. I'll give you another 30 minutes, and that's fine. But I just let me bring up one other thing. To me, I think Rule 26 is interesting. Structural error we've not talked about.
Yes, let's do that.
I feel like that's worthy of a discussion. And Rachel, whatever strength or weakness you think exists in my Rule 26 analysis, I've not heard anybody, and the court, to the extent that it addressed it, I just emailed you, and I think you were kidding when you said you're wrong when I explained to you my view of what I found. That the court talked about the structural error after saying it didn't apply. The court cited this case called Emanuel and says, while a trial court's reliance on extrajudicial information may give rise to a claim of bias apart from structural error, see State versus Emanuel, the critical inquiry that would require reversal is whether the conduct demonstrates deep bias or deep-seated favoritism. The case that the court cited says the exact opposite. And I emailed it to you, and I highlighted it.
State versus Emanuel?
So State versus Emanuel was a criminal case, and the lady was accused of stealing money. And apparently before sentencing, the judge went and talked to lawyers that knew her and asked about her background and so forth. And then admitted to that during the sentencing hearing. And she says, hang on a minute, you're biased. And he goes, no, I'm not. And he sent her to prison, and she appealed. And the only issue was the judge doing this interview of other people that she did not know about until it was too late. It was already over, and she won. There was no showing of bias required. The only showing was the improper investigation. That's the only thing that happened. Show me anything in the manual that supports what the trial court cited it for. It's not there.
Because the question is where a trial judge personally investigates a defendant's background, ex parte, prior to sentencing. Must he recuse himself from sentencing?
Right.
The basis for recusal is bias.
Right. Well, it's bias or prejudice. It's a little bit. A judge who engages in unlawful conduct is biased by definition. I don't know what. Huh?
When you say unlawful conduct, what's your definition of unlawful?
Unlawful in Emanuel, it was an interview of witnesses ex parte.
Multiple interviews of ex parte witnesses about the defendant's character, which is one of the key issues in sentencing.
And in the Kentucky Marchese versus Abersold case that I cited.
Let's talk about that.
Let's talk about that. Same thing, same exact thing. And I don't know how you can say with a straight face that you don't think it's the same thing. But
what was the structural error in Marchese?
That the judge, in the middle of an order of protection hearing, said to the defendant or the respondent, give me your social security number. And he reluctantly did. Then she took a break and she went back in her chambers, and she comes back and she goes, oh, you have a criminal charge from Florida. So without ever explaining where that information came from, it doesn't in neither the Court of Appeals or the Supreme Court of Kentucky's decision. Is there any explanation of what exactly the judge did to find that information? And again, so we're speculating about what she did. Did she go back in her chambers and call her dad, who's a cop? Did she consult some online database? We don't know, but we do know that the judge looked at or considered something that was extrajudicial. And the Supreme Court of Kentucky said absolutely not, after the Court of Appeals ruled against the guy. So exactly our case. No?
Error. The structural error in Marchese was the judge's failure to recuse. It says it right there.
Right. Correct.
It says it.
Right.
Yeah.
Right. It was the failure to recuse.
Right. Recusal and my notice of change of judge for cause is the same exact thing.
I agree. I agree with that.
Okay. So, yeah. and Mata did not, well, the issue of whether the misconduct happened can lead to recusal, but it also is just a due process violation. Just call it something else. It's just a due process violation. And if a judge violates your due process rights, that is a ground to appeal.
But putting a single fact that is really neither here nor there into a 13-page finding of facts that didn't have evidentiary support at trial is not that. It is not grounds for recusal.
So where did that information come from?
I don't know.
So
have you been able to prove though Your big thing on Mata is she went to my blog, she got it from somewhere else because it wasn't a deposition. But you haven't been able to prove. It's still your assumption, and you're just guessing.
What? No. You're flipping that. You're taking the inverse of the correct rule. The correct rule is: did she look at something in court that supported that finding? No. So we know that finding had to come from something out of court. It had to.
What if it was wrong?
What does that mean?
What if she put in an incorrect fact? What if she misheard testimony? What if she heard something during a break that she misattributed to something in court? What if she knew because she's been to Planned Parenthood before? Now, you're still not supposed to introduce extraneous facts. I agree with that. However, every time that happens is not grounds for recusal of a judge.
No.
Let's say she has just been to Planned Parenthood in Los Angeles herself 5 times. It's still not appropriate for her to include that finding of fact when it had no evidentiary support. And we all agree on that, right? But that's not grounds for recusal.
We do not know in Marchese what the judge looked at. And like I said, it could have been that. I mean, what are the realistic options? It's either she went back and went on a computer and consulted some database that she had, or she called a friend in law enforcement. Probably the 2 most likely options. Nothing in Marchese says that I have any obligation to prove exactly how the violation was done. Okay. Right. But if you guys look, if you feel comfortable in saying with a straight face that you don't think I'm right, do you honestly think that Mata didn't go and look at a blog or a post or something? You don't think that happened?
No.
How do you think it got into the ruling then?
I don't know. I do not think she's going on justice for Clayton Reddick. I don't think that happened.
You don't think so? The fact that her father was there and that people in the crowd said that he had told them that he had been discussed.
It's hearsay.
Yeah. Where are the people?
I'm sorry?
But it's hearsay.
But okay. Hearsay is a rule of admitting evidence. I'm not trying to admit evidence of this. I'm asking you as a human being. Right. Mata, the morning when we got there, pulled us into the chambers and said, "Oh, I've set up an overflow room." How did she know that an overflow room was needed? Why did she think that there was going to be a crowd? How did she know that? Where did
hadn't there already been testimony in the court of people taking this to the press?
I don't know what you're talking about. What do you mean?
Hadn't it already been before the court that these issues between Laura and Clayton were aired in the press?
I mean, again,
all over the pleadings.
If you're talking about that months earlier, Laura had talked to the Sun or something, was that revealed? Yeah, to my knowledge, of course, Woodnick complained about Laura going to the media. That doesn't tell you that how Mata knew there was going to be a crowd of people. I mean, maybe she just assumed that, but you can't use that argument with something so specific like the Planned Parenthood is closed on Sunday in Los Angeles that never ever was mentioned at trial. That how she would have known that was an issue. I mean, I guess she just guesses lottery numbers like verbatim and just invents them from thin air.
Or thought she heard it.
Thought she heard it.
Yes, she got this fact. Okay, now the fact that it's a fact, does that matter to you? The fact that she included a fact that we all agree is true.
Well, in Marchese, nobody said that the criminal record that the judge found was incorrect.
Right, but that was inadmissible. In Marchese, there were reasons that her findings would have been inadmissible, which was a critical separate finding that the court made, that would have been inadmissible.
Admissible or not admissible is not the point. Okay.
But it is.
No, it's not.
Isn't it?
No, it's not. No, it's the method used by the judge to get the information. Now, I accept, Rachel, that if you think that Mata putting that finding in there is not by a preponderance of evidence standard, does not show that she looked at social media.
Correct.
I can't argue against that. You're entitled to think that way. I think that's one of the more ridiculous things I've ever heard.
And you think because of that, she should not be a judge in Arizona and should give up her robe because
Steve, no, you don't oversimplify things. My complaint. Hang on.
You've said that, I think.
My Lord, Steve, my complaint about Mata is more global than that.
Okay.
It's more global than that. My concerns are that her conduct throughout the case while I was involved in it is unlike anything I've ever seen in any case ever. Okay. The very first thing I filed was a request for extension of time to respond to Woodnick's motion to compel because I didn't have the file. I filed that the day I was hired. The very first day I was hired, I didn't have the file from Laura's prior counsel. I couldn't respond to a discovery motion that argued that disclosures had not been done because I didn't have the file. So I didn't know what disclosures had been done. So I make that request and she denied it without Woodnick even opposing it. You think that's normal, Rachel?
I can't say normal, no, but we have plenty of family law judges here. We have plenty of family law judges here that want to move things along.
Okay. Responding to a request for sanctions in the form of a motion to compel without giving me the courtesy of a brief extension that I had good cause to request, that's not normal. But look, hang on. Wait,
that's not the norm.
Wait.
I would think that's not the norm.
Wait, that's issue 1 of 10. Okay. Woodnick then refuses to talk to me. Do you know how hard it is to litigate a case like this when you're new to the scene, you have a trial date already coming up, and opposing counsel won't speak to you? Which
what would you have said to him?
Oh my God. Do you know how many hours a day I spend on the phone with opposing counsel talking about every single possible issue, settlement, witnesses, documents, discovery? All of these things require counsel to speak to each other. It's a professional requirement. Yes, you agree with me?
I think it's a professional helpfulness. It's not necessarily a requirement. You know that. But I agree. No. Look, I talk to opposing counsel all the time. Okay. But what were you going to resolve with them? Right? Laura was already given an opportunity prior to that for a free out.
Oh, with a big contingency. Yes. Here, sign this thing in it.
Truth. Yeah.
Okay. The fact is, so hang on. So I'm just
saying we're not going to agree on that because you're going to say, well, you think she was lying, and I don't think she is.
Steve, what I'm trying to tell you is in my forming of my opinion of Mata, it's not based on this one thing at trial, which is what you're trying to suggest. That is absolutely untrue. It is based on multiple rulings that she made that were completely, in my opinion, groundless, against what the rules require, and prejudicial to us for no apparent reason. That is what led me to say that I don't think she should be a judge, because it looks like she picked her favorite winner, I think sometime early on, and then made rulings to ensure that that guy won. That's what it looked and felt like to me as a participant. And that's not a good feeling. And do you think Laura or her family or anyone on our side thinks that the court worked here, that the process was fair here?
Of course they don't think that, because she
Steve,
lost.
I've literally had JFC people reach out to me and tell me they absolutely see my point with Mata, that they think what Mata did was absolutely disgusting. I've had people that support Clayton reach out to me and say that. I have written DMs on Twitter from people that hate Laura, that think that she lied, and they say, you know what? Mata still, the way that she did this was not what a judge should be doing. And that's their opinion.
I don't know your other qualms with her other than her findings. So I don't know the whole history of the bar complaint. I haven't read her bar complaint against you. I haven't read yours against her. So I can't weigh in on anything. I don't think there was anything improper within that Planned Parenthood thing, but I understand your basis. You have a broader basis for complaining about her.
Yeah. And Steve, Steve, you probably know this, but the issue with, you said, well, this fact that she found about Planned Parenthood's business hours, the fact isn't wrong, so it's no big deal, right? That's not the point. The point is, if she was online looking at anything about this case, there's so much negative media, social media about Laura. Who knows what else Mata could have seen? That we don't know that. And that's why this cannot be judged under a harmless error standard, because if we do that, that requires me to show prejudice from what she did. And how can I possibly show what she did when I don't have access to that information? Because I can't depose her. I don't know. All I know is she looked at something that she shouldn't have. And it might've been, she looked at 100 things that she shouldn't have. We don't know. We don't know. We don't know. No,
but let me ask you a hypothetical. What if she said, oh, I Googled what hours Planned Parenthood was open. I shouldn't have done that, but I did it. And I found out it was closed. Let me ask you that. If she had said that she did that, which I'm not saying is what happened, but would you still believe?
I would make exactly the same argument. And do you know, Rachel, I mean, I don't know how much time you spend. I understand that you have a life and you have this case is not every minute of your life, right? Nor is it mine. But one thing that I've brought up is somebody else on this judge complaint website called the Robing Room.
Oh, I know the Robing Room. That's one of my biggest issues with you. That you cite the Robing Room as like really good evidence that there's something wrong with Mata. It's the disgruntled, crazy litigants that go in Robing Room. But regardless.
Well, you can say what you want. I've represented a lot of websites. I understand people post things that aren't true. I read that comment about Judge Mata ruling against, taking children away from a parent based on a Google search for a snake. Is what that person said. That's what they said.
But but did you follow up on the case? Did you vet it? Did that actually happen?
All I can tell you is I reached out to the person that submitted that and I did not get a response. Okay. That's all I know.
Then it's just a troll it's no different than a troll that trolls you on Twitter.
But what if it's true?
But what if it isn't? You haven't proven that it's true.
I mean, that's like when you say, like, look at the Robing Room. This is proof that there's something wrong with Mata. The Robing Room, every family law judge in Los Angeles, the good ones, the great ones, and the not so good ones, have countless reviews on Robing Room which say, this person took my kids away from me because I'm a man and she hates men. This woman took... I don't believe a single one of those, even for the judges that I don't think are as wonderful as others. Okay, I think that's all BS.
Yelp for judges. It's Yelp for judges.
Okay, guys, look.
And you were using that as a very strong argument against Mata. You kept bringing up that case, like you said.
Robing Room.
Because
you have no idea if that case was true, what that person wrote in the Robing Room.
And you have no idea that it's not true.
And
all I'm saying,
you based every part of your argument on it.
So
you kept saying it is true.
No, I didn't. I never said that.
Okay, but continuing to use it as an example why Mata sucks. You're basically giving it truth.
It's consistent with my contact with her that it sounded true to me, and it is what I observed myself. Okay,
sounded true. Okay. One thing here. Obviously, there's
and Steve, we got about 15 minutes left, so if we can kind of wrap it up or whatever.
Something that was brought up in the last video, the video you posted a couple of days ago with Laura, the very end. And I just, like I presented every question to you and then you talk and then Rachel gets 5 to 10 seconds before you sigh. So I want to go to Rachel with this first, but it's because it's something that you said. This came out of your mouth. In the end of the video, you were talking about, Laura, I hope that you never pay Clayton. Mm-hmm. Then you brought up the Trump situation. Mm-hmm. He filed bankruptcy 6 times. He's famous for stiffing creditors. You could file a bankruptcy. Either way, there's no legal requirement for you to post bond if you don't have the money to be collected. And she said, I don't. I want to talk about this for a second, because in the trial, didn't Laura admit to having $200,000? Where did that money go? What do you mean she doesn't have any money? And this whole thing about, I'm just not going to pay? You don't want her to pay? You're telling your client, hey, ignore this payment of $150,000. I need a little more explanation on that. I think a lot of people do.
Is that going to Rachel or to me?
No, actually,
we'll go to you on this. Yeah, explain that.
So I'm glad you asked about it, because I think people. Okay, here's what I'm going to say. And I tweeted to somebody, or I maybe responded on the YouTube comments to somebody that raised the exact same question. What I'm authorized to tell you is Laura does not have any money. Okay, she doesn't. Her income has basically been destroyed, and she blames JFC for this. She says that JFC has, harassed her podcast advertisers to the point that they won't work with her anymore. And her income is basically zero now. And she never said that she made $200,000. What she said was that was what the podcast made, and she split that with her mom. That's over now. Okay, that source of income is gone.
So the $200,000 that she said at the trial, she no longer has for whatever reason. She was saying that was her income from the podcast that she was doing with her mom. The podcast is not podcasting anymore. That you can't, I suppose you could do a podcast with no advertisers. You're not going to make any money. Okay. So then just correct me if I'm wrong here I thought the judge asked her, how much do you have in some sort of account at this moment? Didn't they ask her that? And she said 200,000?
No, they asked about income and her income.
I don't remember.
Anyway,
right.
Steve, whatever the number was, whatever her income used to be,
she doesn't have it now. Okay.
Her income is zero. basically zero. Her assets, they are what they are. Clayton is entitled to go and look for that. Dude, he can collect his judgment all he wants. That's what the bond that people think that Laura has to post. The posting of a bond is only if you want to stop the plaintiff from collecting. Laura hasn't posted that bond because Clayton, you can't get blood from a stone. You can't get money from people that don't have it. So Steve, look, this has been a friendly conversation and I don't have any problem with really anything you said, but don't say that I'm encouraging her to ignore an order. That she's not sitting on 10 million in cash. And I'm just saying to her, go hide that.
Yeah.
She doesn't have the money. She sent me a screenshot of her bank account the other day. I almost cried. And I feel bad for her. And all I was saying is if she wanted to, and actually Laura asked me to bring this up, because in her mind, it weighs in her favor. And you probably will see it exactly the opposite, because that seems to be the way we're going through this. I said to her a while ago, just if you file bankruptcy, you don't have to deal with this anymore. You just push that red button on your desk that says, boop, I'm done, bankruptcy. The entire case goes away. Clayton's ability to do anything to her in court anymore stops the minute she files bankruptcy. And she won't do it. And she said, I'm not going to do that, as much as it would bring her relief and it would make my life easier, because I'm doing all this work for free, right? People.
So that's my question. Why?
Because I believe so strongly that she has been treated unfairly, and that what has happened here is wrong. I believe that in my.
If you're looking for somebody who's been treated unfairly, I mean, and that's one of the things I don't understand. Like, I mean, all you have to do is read a lot of these. You may say, I don't know if they're true. I don't know if they're accurate, but read what she has done to these men. Read the emails with Clayton, the emails with Greg, the text messages with Mike.
You have admitted you know nothing about the Maricini case. You've never spoken to Mike. You've never spoken to Greg. You've never read.
I have never seen coercive control as badly as what she does to them.
Yes.
Okay.
So
hold on, wait, just let me finish. Okay. All right. So there are a lot of people sitting in jail who have been treated unfairly by the system. Why not give your services to someone like that? Like, if you're doing this, because you're fighting for what's right, I get that. But find a worthy person.
Rachel, I have known Laura for 1 year now. I have worked on her case. Well, at the beginning was more intense. Obviously it's kind of gone quiet because we're done with the litigation side of it, but she has become a friend. I talk to her often. I have spent a lot of time with her, way more. I mean, you guys have no knowledge that I do as far as contacting with her personally. In the last year, I don't know the person that you're describing, I guess is what I'm saying. I've never seen her behave other than reacting when Dave Neal makes a video and just rips into her. She is emotionally devastated by that. And I keep saying I can't judge how she's reacting, because anybody that went through something like what she's going through, I think would react badly. But in terms of her, Rachel, what you just said, her coercive, controlling behavior and all this and so forth, I've seen none of that. She's certainly never acted that way towards me. Okay.
So will you go look at it and then?
Yeah. Can you at least?
Why?
You got to entertain us. Then you have to go look at this stuff and then come back and say,
because it's kind of hard.
This is huge because this. Yeah, Rachel, the point that you and I talked about. Tell him what we were talking about in regards to this.
Look, I agree that everybody deserves representation. Everybody, I don't fault a lawyer for, representing a criminal defendant, for representing somebody who's on the wrong side of an argument, right? Because that's what lawyers do. But you've gone beyond that, right? I mean, you have, what you said was, I hope Clayton never gets paid. I can't believe what he's done to you. I can't believe this is so terrible. It's so hard. You've given her a platform. You've put her on your videos. You've sort of given her a platform to put forth this victim mindset. I've been victimized by these men. I've been victimized by the system, right? When
to respond to people making that claim.
I mean, I want to read you a sentence, right? I would still get a surgical abortion this week and drop the case if you choose to pursue the relationship you claim to want with me. That is so manipulative.
And
that's from an email from her to Greg Gillespie that I believe was from her to Greg Gillespie. I can't myself verify that it is, but something that purports to be. Right? I mean, why is this a person that you want to put forward and say is deserving of our sympathy because of all the people that have victimized her?
Rachel, if women treating men badly is a legal issue that warrants financial destruction and social media harassment for any woman who treats a guy badly, if that's how you see it, I don't see it as a legal issue for the courts unless something becomes criminal or is harassing. And Clayton has his order of protection. Laura has not done this. All of these events that you're describing happened almost 2 years ago, right? But
Laura's the one that brought all these things into court. Laura was the one that dragged these men into court for abortion coercion.
Years ago?
Right.
Yeah.
And she's not doing that anymore. So leave her alone. Let her.
How do we know she's not going to do it again, David? She's done it 3 times with 3 men. How do we know she's not going to do it again?
Okay. Well, guys, I'm not in charge of Laura's love life or her future. That's between her and whoever wants to date her. That's not a legal issue that as a lawyer I have any concern over. I will tell you, Rachel, I agree with you that I have read some things that Laura did and wrote to Clayton that I don't endorse. And I'm sure that if somebody went through your entire life, history of emailing men or whatever, no, really, you've been perfect your whole life?
Never said anything
Never told someone that if they date me, I'll have an abortion.
Yeah. Okay.
Nothing like that.
I'm not endorsing every little thing here, but I'm also saying I don't care. This is such a private life issue and again, it became an issue because she went to court over it, and that's her fault. I'm not asking. She took it to the media. Yeah. And she reaps what she sows. I give you guys that.
Yeah.
But at some point, she has tried to stop this with Clayton, and you guys haven't let her.
Then why not have her sign a judgment of confession? Why not have her say, look, I'll give you the $150,000, but I don't got it. Why not stop the appeal? Say, I'm broke. Fine. Enter judgment against me. I'm broke.
There already is a judgment against her. She doesn't have to concede that.
Right. You're totally right. She could just stop the appeal. I was just kind of fast tracking everything. You're right. Just let go of the appeal. Just stop it. He'll never collect it.
You guys, all that I can tell you is she feels that she has not been treated fairly, that the law has not been followed. And I agree with her. You don't agree with me. We'll get there. We'll figure out who's right and wrong.
She treated Clayton fairly?
I think it's a personal issue that is just not my part to judge.
But she brought it to the courts.
Rachel, right? If I had been involved in this from day one, every single aspect of this would have been handled differently. And I have no problem with Clayton feeling angry. I have no problem with that. I'm not taking anything away from that guy's right to feel whatever he's feeling. What I have a concern with is I have a completely different outlook on what this case really was. I think this was Greg Woodnick getting revenge against Laura for her emailing the judge in the Gillespie case and saying, oh, I think Woodnick was involved in me being raped. That's what I think really went down here. Why else would Clayton?
Not the whole case. You mean the latter portion of it, obviously. Not the whole case.
Correct. No. Since Woodnick got involved, that to me, and what Woodnick has done to use this case as a vehicle to exact revenge against Laura, I think is actionable. I think that is abusive process, but that's my opinion. And, Laura wants me to sue Woodnick right now. And obviously I haven't done that, but I'm actually more of a peacemaker. I would like to see everyone stop this and leave each other.
Then why is she threatening all these people with lawsuits?
Yeah.
Why are you telling her, don't threaten Dave Neal with a lawsuit? Don't threaten this podcast studio with a lawsuit?
Rachel, people have a right at some point. They have a right to privacy. Laura says that Dave Neal has lied about her. She says that. Okay. I don't want to get all into that. We need 3 more hours, but Laura has a right at some point to say to people, leave me alone. I'm not going to be your punching bag forever. She's gone through hell.
Then why is she still posting blogs?
Why is she posting blogs? Why is she going on your videos? If it's so mentally draining for her and bad for her mental health, why are you putting her on your videos?
All she's doing is responding to things. Okay. If JFC would leave her alone, she would never post anything again, probably, unless it was about horses or, country music. Okay. But if you guys make statements about her or attack me or the Court of Appeals, Laura has a right to let people know what her side of the story is. We've done that. We've done that. So look, I would like to see, I love cases being resolved. I don't want this to go on for another year. I don't, but Clayton and Woodnick have given us no choice. If they want to talk, well, I don't want to talk to Woodnick. I'm happy to talk to Marcus or anybody else from, I have no problem with those people. I mean, guys, as much as this has been a little bit of a heated debate, I think I'm a reasonable person. I may take positions that you don't agree with, and maybe ultimately I wind up being wrong, but I don't think I'm that hard to talk to, Steve. I mean, you and I have talked. Have our conversations been okay in your opinion?
No, every time I've talked about the fact that our conversations, they were never contentious. I didn't agree with a lot of what you said, and you didn't agree with a lot of what I said, but I said they were never contentious. But my main point with you has always been the David Gingras that I deal with on the phone is a completely different person than the guy on his blog, on his tweets, and on his YouTube channel, because you come across as a giant asshole.
Totally.
And you don't do that. At least in the conversations with me. I think there are people that will watch today's video and get fed up with your sighing and get fed up with your interruptions of Rachel. But that's a completely different thing. But between me and you, our phone conversations have been perfectly fine. But it's just when it gets to when I read your tweets, when I read your blog, when I watch your videos, I'm like, he's just a different person. This isn't the guy that I talk to. And I don't know why he takes this persona of chest thumping and I'm always right, and you are all idiots, and you're all a cult, and you call JFC a cult, and honestly, they have unearthed so much more about this case than you even know. So clearly, they're doing something right.
Okay. So just to close out with one final thought, you guys have made some kind of moral arguments, and Rachel, you talking about Laura sent an email to Clayton saying whatever she said about abortion and whatever.
Oh, you guys was to Greg. That
was to Greg. Yeah.
Oh, okay.
It was one of like 7 or 8 sent within a several day time frame, including ones that said, "This is the email I'm going to send to your boss."
Right. Like okay. You're aware of things that JFC has done in retaliation or response to what Laura, sending a flyer to her gym saying "warning" with, all. Have you seen that flyer, Steve?
Yes, totally wrong.
I don't agree
with that at all. I agree with you.
I do not think it would be appropriate to send any flyer, though I have not seen that one.
I'm with you on that. Absolutely wrong.
Calling the police and asking for a welfare check, and then getting the body cam video and putting it on YouTube and laughing about it when they're standing there in their Christmas outfits. Is that okay? I'm just saying. So, Steve, the reason I'm bringing this up is because you asked, why am I like kind of reasonable and sitting here talking to you, or at least friendly enough, and then why am I a jerk online? Yeah. Right. And the answer to why I'm a jerk online is when I'm tweeting or responding to people, it's usually because some event like that has happened. I have Laura in my ear crying. I have her begging me, can you make these monsters stop attacking me? And I do get upset about it. I feel bad for her. And I get a little emotional. We all do. But that's what you see. That's when I'm responding to somebody after something has happened that makes me feel the need to respond. You're not getting the best version of me. I admit that, Steve. I fully admit that. And I'll tell you, I give you my apologies for if I've ever been rude to you. I don't think I have. Laura said that you were shit posting about me and being rude to me. And I don't mind. I don't mind.
No, it wasn't. It was the gloating part. It was the loss and putting up your clips of saying, "No way in hell Clayton's going to win." And I gloated because you lost and got your ass kicked on a case.
I think the San Francisco 49ers are going to win the Super Bowl this year. Yeah. Whatever. Okay. We have disagreements about picking our favorite team. You and I can have an adult conversation. And Rachel, I don't have any problem with our conversation today. It was frustrating to me. I'm sure you were frustrated with me as well. But we need to have respectful conversations with each other on both sides and continue moving forward. I appreciate you having me on. I wish I had kind of better answers to give you on some of these things. I got what I got. Okay.
So if Laura threatens to sue me as a result of this podcast,
she's not gonna threaten to sue you. She won't. No. You
I'm not worried about a lawsuit, but I'm saying, that there's been a lot of, we're going to sue this person and that person and this person and that person.
Part of that, guys, is I think this needs to go to a next litigation, not before MATA, but where everybody can get all of their questions answered. You guys have all these questions. Laura has questions and claims. We should probably go fight that out in the right forum rather than on social media.
Why not just let it die? I mean, that's what I'm kind of asking. Right?
Tell Clayton to let it die. Tell Clayton to let it die, and we'll be done tomorrow.
Wait,
I don't think Clayton's doing anything.
What's Clayton?
Well,
I mean,
really?
he posted the
He posted the Court of Appeals and say, "Hey, I won." Just allowed to say that.
Well,
if you would have won, I mean, obviously, if you would have won, you would have gloated too. All Clayton did was gloat that he won. Court of Appeals ruled in his favor.
I understand, but at the end of the day, the only reason any of this is happening is because Clayton is insisting on pushing forward. You know, he's got this judgment against Laura. What's she going to do?
So don't appeal it. Say, you know what? I don't have the money. I'm done with this. Try and collect.
Well, the problem with that is that gives Laura no way of redeeming herself, and she wants that opportunity. She wants her opportunity.
She's the one that's continuing this. I'm not saying she doesn't have a right to do that, but you just said this won't stop because of Clayton. No, it won't stop because of Laura.
Well,
what 4 judges have now ruled. She could accept what 4 judges have now found and said, you know what? I don't have the money. I don't have the money to pay this judgment. I'm going to respect the process so far. I disagree with it. But it has to end. I don't want this for 2 more years of my life. So let me again, I'll flip something around and then we can cut this off. I'll flip around and I'll give to you exactly what Woodnick gave to Laura. Why doesn't Clayton just sign a statement saying, you know what? I think Laura was pregnant. Why doesn't he just do that? Why would he do that? Laura's the one that knows whether she's pregnant or not. He doesn't know.
All I'm saying to you is, that's
ridiculous. Come on.
It is ridiculous. It's intentionally ridiculous.
So then I was trying to think, what was the point of that then?
Because you guys act like all Laura had to do back at the beginning was sign a statement saying I was never pregnant, and then Clayton would have let her out. That is exactly the same thing as Laura saying to Clayton, here, sign something saying that you raped me, and I'll drop the appeal. Clayton knows it. Clayton knows if he stuck it in or not. He does. But
raped her? He would confess to a crime?
It's intentionally absurd what I'm suggesting, Rachel.
It's not, because the truth is, I think, from everything we can tell, that she wasn't pregnant.
But was she sexually assaulted? You don't know. I don't know. And I'm not making that claim. I'm just telling you that what you're suggesting that Laura do is exactly the same thing as her asking Clayton to admit, oh yeah, I did sexually assault her. He's never going to admit that. And Laura's never going to admit that she lied about her pregnancy. So we have that.
Okay, but I understand that. I understand that she's never going to do that. But that's a way out for her is to admit it. To
admit something that she says is not true. That's why I use that absurd example about Clayton, because he says that's not true. So nobody's going to sign something that admits something that they said is a lie. They're just not going to do that. So
unless they finally just give the gig up, right?
Hey, you know what, Rachel? What if Rachel Mitchell goes and charges Laura at some point? And I'm sorry we didn't get a chance to talk about that. I actually have a lot.
Look, I understand, but I don't think that was even on the horizon when she was given the opportunity. I understand why she wouldn't sign it now.
Yeah,
I completely understand why now she wouldn't say I lied under oath.
No, totally but ultimately, if that happened, and if there was a criminal case, there may be a resolution of that. I don't know. It'd be interesting to see how that fleshes itself out in terms of getting all these questions answered. What if Rachel Mitchell has proof that Laura was pregnant? I don't know what that would be. I mean, she's been running around subpoenaing things, apparently. I assume she has. But ultimately, it's just so complicated. I'm just saying we need some closure to this. I'd like to see that happen. If you think that I'm pushing forward with this for anything other than I'm trying to help somebody that I feel needs help, that's all I'm doing.
I'm just confused on the last part that we talked about, which was Clayton is continuing this going. You're doing a reconsideration. You're going to file with the Arizona Supreme Court. You're going to file with the U.S. Supreme Court. How is that Clayton continuing this case?
And she could let it go without admitting she did anything wrong. She could just stop the appellate process.
You just stop. Yeah, just stop.
Well, look, Clayton and Woodnick are the ones who wouldn't let Laura drop the petition. They're the ones that dragged her through 6 months of litigation. They're the ones that made her. Laura spent tens of thousands of dollars in attorney's fees. I don't know what Clayton has actually paid Woodnick. I don't think very much. I know it's not 150,000. That's a number that's kind of made up, which is okay. It's okay. But Laura paid me out of pocket for all the trial work. She paid my normal rate. Okay. And it was financially devastating to her. And so to suggest that she just walk away now, she thinks that, everything that has happened to her is illegal and that she should get fees. And, I see it that way too. I know you.
So she's basically doing what you criticize Clayton for doing. Perpetuating it just to vindicate oneself.
No, the difference is that Laura has actually suffered damage that Clayton didn't suffer. Clayton didn't, when Laura moved to dismiss the petition, Clayton did not have $150,000 in fees. You know that.
I agree that he didn't have $150,000 in fees.
And Laura does have the actual damages of the fees that she's paid me, which are tens of thousands of dollars. She has the actual damage to her reputation that this has caused from all this ongoing.
But Clayton had all of that as well.
Which could be remedied in another way.
But why are you raising it in support of why you're perpetuating it?
I'm just saying it's no different. I'm saying it, look, Laura has an argument to make and she's making it. But look, if we could find a way to end this thing, I would be the happiest guy in the world.
But can't we?
Yeah.
I don't know. Tell Marcus to call me. It's ridiculous.
Last thing would just be a request for you, because this is just my request to you. And I'm not even going to talk about changing the behavior online because I don't think you're going to.
I'll try.
My request.
You make the request after I jump off because I got to run.
Go. Nice meeting you, Rachel. Nice meeting you.
Yeah.
And you as well. Bye, guys.
All right. Bye, Rachel. So I guess my request at this point, oh wait, there she is. Okay. Would just be I know you have said like, hey, I was going to say Rachel, the Laura that I've known over the last year is not the Laura that a lot of people online think of her as and whatnot. My only request to you would be, I understand your stance because you've gotten to know Laura, this person, over the last year, but self-admittedly, you don't know anything she did before April of 2024, before you took over.
Sure.
You know very little.
Sure.
Very little. So that would be my request is I really, really, and I will send you, I've got them all. I will send you, I want you to read the emails that she sent to Greg and Mike. I want you to read those. And it might not be the Laura that you know over the last year, but this is part of Laura's past. And my whole thing with you is, while you staunchly defend your client, the problem is you self-admittedly don't know what she has done before you took over. So you can't say with 100% certainty, this is Laura Owens. It's the Laura Owens you've known since April of 2024.
Fair.
Plenty of behavior before that you are unaware of that I just want you to read about.
Steve, I'm not going to reject out of hand what you've just said. I'm not going to reject because I don't know what you're talking about. I don't know what specific things you want me to read.
I'll send them to you.
All I will say to you is that I generally understand what she's alleged to have done. I generally am familiar with that. I don't like what I've heard that she's accused of doing. She tells me a completely different story, and I'm stuck in the middle. Yeah. What I will say is, I don't believe that anybody cannot change. I think people can change, because I know myself, Steve. I was such a jerk as a kid. I was. If you think I'm bad now, I was much worse when I was younger. All kinds of trouble, and I've tried to fess up to that and own up to that, because I feel that when you make mistakes and then you admit them and you own them, that's a powerful thing. Okay, and it's something that, with regard to Laura, I guess what I'm saying to you is, I'm judging her by what I see right now. Okay. If you send me 1,000 emails that show that she was really in a bad, acting badly 5 years ago or whatever, I don't know how much weight I can give that when the person I see today is different. And all I'm saying is, she could have gone through a really tough time in her life when she was doing drugs or something. Or I don't have any knowledge of that, but people go through problem times in their life and they do things that they shouldn't do, and then they emerge from it. and I'm focused on the future. Okay. The past is interesting. I'm not telling you it's not, relevant to anything, but if Laura can get herself to a better place and leave all this behind and not engage in any conduct that looks weird, which is my experience with her, that's what I want to focus on. So that's where I'm coming from. I'm a forward looking guy. You can't tell me that the mistakes you made in the past define you today if you're willing to change. And yeah, I know you want more than that.
Yeah,
but
I believe absolutely people can change. I know I've changed in the last 5 years since I was dealt with some online criticism for something that I did, and I have changed the way I have approached my job, my spoiler job, how I report things about contestants on reality TV. I've definitely changed the way I've done it. But in Laura's case, I know you're kind of throwing it out there where, hey, what if she was going through this? This was a long time ago, but it was continuous. It was Greg. It was Mike. It went all the way up to September of 2023, 6 months before you took over, 7 months before you took over. So it's not like it's been 5 years since she's done anything wrong or has sent an email that was very manipulative and very controlling and, sending Dave Neal an email threatening to kill herself. And as she said, if I do kill myself, the blood is on your hands. Do you think that is something that's normal?
No, I think it's terrible. And I again, for me, my view of it is punishing Laura for being too emotional at a time or engaging in conduct. I see it as a sign of somebody who needs help as far as whatever she was going through.
Think she needs help. We all do.
Okay.
Do you think she does? Just out of curiosity.
Based on her behavior today, I'm not seeing what you're describing. Okay. So I'm not gonna sit here and I'm not dating her. Right. So I'm not evaluating her as that situation. So in the limited role that I have in her life, I don't see what you see. And her behavior to me looks like she's responding to one of the weirdest situational problems as far as the JFC that anybody in her shoes, I think, would act not normal because what she's going through is not normal. And what I do see, what I can tell from her, she's a good kid. I think of her as a kid. I know she's not a kid, but I see her as a good person. She loves dogs. She loves horses. She has a great relationship with her family. She loves her sister and her nephew. And she is just a normal person who's maybe gone through some weird stuff and maybe did some things that she shouldn't have. Maybe. Okay. But to keep tearing her down when I feel like, look, I'm not seeing the conduct that you're describing. If I saw it, Steve, you think I wouldn't just run for the hills?
You're saying currently see it.
Yeah.
But if you saw it in emails from 2018, 2020, 2022, you're just going to dismiss it?
Well, I'm not going to judge her for it. That's not my job as a lawyer. I mean, again, I'm not her therapist or her, a person that doesn't matter to me as far as my job as her lawyer. I'm just trying to make these legal arguments and to get her case closed. As far as what she needs in her personal life, that's between her and her family, and really not between you. It's none of your business. If she has a relationship with another guy in the future and engages in conduct that hurts that person, that's between the two of them. Okay. And again, I've had bad relationships in my life. I think it's I find it hard to understand why Mike's version of what happened, how was he hurt by any of it? I mean, maybe if she was acting as weird
not
as
being able to get a job because he's got an OOP on his record,
which he stipulated to.
But there's a lot of, again, this is the problem because you haven't read anything about anything that happened in that case.
Well, but Steve, what I'm saying to you is let's say that Laura faked having this cancer thing with Mike. I don't know what the story was with any of that because it's just not part of what I've been, able to look into. If all that happened or if Laura was weird and manipulative in emails to Mike, why doesn't he just break up with her and just end the relationship? Why isn't that the only, resolution that's needed?
I don't think it would have mattered. You think she would have, if he would have said, "Hey, Laura, I'm done with you." You think she would have stopped based on what we know and the emails that she sent Clayton? Do you really think she would have stopped? Clayton told her in a car a day after they hooked up. He told her in a car, "I'm done with you." And then she had 500 phone calls and emails to him. That's how he got an OOP.
Well, the 500 number is he said it was 100.
Yeah. Okay.
I know.
50. It's 50. It's probably 49 more than it should have been when a guy tells you in a car, I'm done with you. Sorry. What happened?
So block and move on.
But he did block.
Well,
she would create other. See that? Well,
there
we go.
No,
you don't know about.
I'm not. Yeah, but I'm not. Anyway, I've had bad relationships. They've never gone this level. And if everything you're saying is true, I still feel okay. I still feel there are ways that this gets resolved without the level that it's gone to. I think it's just it needs to stop. So
I think one of the things I took from today is you think this should have been. Maybe I'm putting it out there for you think he should, or you think he should have or should file a civil lawsuit against her or a defamation lawsuit against her?
It's complicated because again, he has a judgment already. You can't get two judgments for the same thing.
But he doesn't have a defamation.
Judgment. He doesn't. He doesn't. And I think that the reality is, well,
I guess my question is, on the layperson, can he file a defamation suit against her?
Statute of limitations for defamation is 1 year, and we are now 2 years into this. So I don't know what Laura has said about him in the last year. You'd have to go back 1 year.
Okay.
That's part of the problem. And she would probably wind up filing bankruptcy then anyway, although certain kinds of defamation judgments are non-dischargeable in bankruptcy, which is a little, interesting and scary. But all I'm saying to you is I just wish that Clayton had let the family case end on December 28th. And if he really felt so strongly that Laura had done something illegal, he should have sued her for it. He might still do that. I don't know. But I would view that entire conversation differently because, like I said at the beginning, I see the family court thing as this little box. It's just a little box of family. It was just a petition to establish paternity. That's all it was. It wasn't open season on either side. It was just paternity.
So on December 28th, he should have said, dropping the family stuff. I'm going after you in civil.
Yep.
Or whatever.
Absolutely.
That's what you think should have happened. Okay.
Yeah. And the reality is, and Rachel's gone, so she can't defend this, but the reason that's so important is because in Arizona, if Clayton had sued Laura for defamation, you don't get attorney's fees. You cannot get attorney's fees for civil tort claims like that. But what wound up happening is they kind of ran around it by using this family law thing, but they weren't litigating a family law issue. They weren't litigating a paternity issue anymore. They were litigating something else. Anyway, Rachel wouldn't agree. You kind of, I know you hear where I'm coming from. You don't agree. That's fine.
Yeah.
Anyway, good.
No,
okay.
This was 2 hours and 20 minutes. I mean, it was a long time. I'm glad that you did come on. Obviously, this will be up on Friday for everyone to watch. I'll send it to you now because I'm not going to edit anything, especially 2 hours and 20 minutes. I don't have the time. I still have to record 2 more podcasts tonight. So, I appreciate you coming on. There were times where I was like, just struggling to be like, this isn't what I wanted. This isn't what I expected. There was definitely some heated stuff there, but I think points were made. And look, I actually wanted to say this in the very beginning, and I'll say it now, but at no point bringing you on, did I ever think Rachel was going to say something and you were going to go like, oh shit, you know what, Rachel, you're right. Nor did I think you were going to ever say anything that she was going to say in the same return. Oh shit, David, you know what, you're right. So I didn't think your mind was going to ever get changed, nor was hers. I just wanted both of you to present your sides, which you both did. And it's just like, it's amazing that you are just so far off, both of you, in terms of agreeing on anything.
We're not
about this.
I think we found some common ground.
Small things, right?
I think we found there is common ground there. It's just the way that Rachel sees it is a very, very twisted version. I get where she's coming from.
She's saying your version is twisted the way you see things?
Of course. Of course she is. Of course she is. Anyway.
So it's an interpretation thing, seems like what it's come down to. It's more of an interpretation, how you've interpreted cases that you cited versus how when she looked at it and she's like, David, it doesn't say that. And you're saying, yes, it does. And she's saying, no, it doesn't. So it seems like an
look, I know you're not a lawyer, but I emailed you tonight about this stuff. Go read the case I sent you and see what you think. Yeah. I gotta get going. Thanks for the time.
All right.
We'll see you.